and soil erosion, which affect the region of Canal d'Ayotte during heavy rainfall. However, as at date, as per my information, there has not been any project to restore or rehabilitate the canal. Mr. Speaker, sir, as it is a national heritage and is of cultural and historical significance for having supplied fresh water to the capital and the port in the 19th century, and is one of the oldest heritage in the region of Grand River Northwest, the NHF is working on the terms of reference for the enlistment of consultancy services for the carrying out of an in-depth structural survey on the canal prior to any restoration or rehabilitation.
Before I ask the question, Mr. Speaker, I'll table a copy, a photo, a picture of the aqueduct as at yesterday, and it talked by itself to see what is the state that this has been abandoned by the ministry. Now, I refer to a letter that was sent to the minister dated 17 July 2022 by SOS Patrimoine en Péril, to which the minister was copied as well as the ministry, and I'd like him to tell me whether there has been a request for a detailed assessment and a detailed structural assessment report to find solution to monuments in Grande Rivière, namely the aqueduct as well at Canal d'Ayotte, whether he has taken cognizance of this letter and if he will do the assessment.
Yes, I have taken cognizance of the letter. Mr. Speaker, sir, as mentioned, several site visits has been conducted with various stakeholders, and there is this enlistment of a consultant which is being envisaged, and the terms of reference are presently being worked on.
Has the ministry got any budget specific this year for the renovation work? Since you are appointing a consultant now, do you have in head any project that you may envisage in this region? Because despite it is in a high-risk flood region, it's still a national heritage and patronyme national. Donc, quel est le projet que le ministère a en tête?
It's difficult for us to foresee any projects, but of course it will be restoration and rehabilitation. But the first step to any restoration project would be to conduct a survey, and this is presently being done with the terms of reference being worked on. So it's a matter of taking it phase-wise.
Matter of good faith, Honourable Minister. It is mentioned in the same correspondence, that is the second correspondence, and then you never replied to them. Will you please reply to this letter, earmarking your project, your intention to come forward with whatever you just mentioned in the Parliament today? Thank you.
Noted, Mr. Speaker.
Rather than proceeding with projects in isolation, does the Minister agree that it would be wiser for the concerned ministry to put in place a holistic plan for the conservation of the numerous heritage assets in this region?
No answer. Next question. Honourable Ramphel.
B953.
Monsieur le Président, en ce qui concerne la partie A de la question, comme la Chambre le sait, dans le discours du budget 2021-2022, il a été annoncé qu'un nouveau Bank of Mauritius Bill et Banking Bill serait sous peu introduit en adéquation avec les meilleures pratiques internationales et tenant en compte la pandémie. À cet égard, j'ai été informé que la Banque de Maurice travaille activement sur les deux nouveaux projets de loi. La Banque mène d'ailleurs des consultations avec le FMI sur la rédaction de ces projets de loi. La législation relative à la Banque centrale reviendra en détail sur le mandat de la Banque de Maurice et les pouvoirs spécifiques dont elle dispose pour atteindre ses objectifs, notamment en matière de politique monétaire, de création des conditions favorables au développement économique et de stabilité financière, y compris au niveau macroprudentiel. En outre, la Banque de Maurice est en train de remanier son cadre de politique monétaire avec l'appui du FMI afin de renforcer encore davantage l'efficacité de sa politique monétaire. J'ai été informé que la stratégie de la banque sera axée sur un certain nombre d'éléments opérationnels et stratégiques clés, tels qu'une cible d'inflation définie et flexible qui ancrera les anticipations d'inflation et permettra une plus grande clarté sur le mécanisme des interventions de change. Les principales caractéristiques du nouveau cadre seront intégrées dans la nouvelle législation. Monsieur le Président, concernant la partie B de la question, alors que les recommandations du FMI sont dûment prises en considération, les autorités restent souveraines et indépendantes dans leur prise de décision. Depuis sa création en mai 2020, je tiens à rappeler que la MIC a grandement contribué à préserver l'emploi et sauvegarder la stabilité financière du pays alors que nous traversions la pire crise de notre histoire. D'ailleurs, je tiens à rapporter les propos de l'administrateur du FMI pour Maurice, qui était sur place pas plus tard que la semaine dernière. Après son entretien avec le Premier ministre, l'administrateur a déclaré que Maurice a réussi à faire face à la Covid-19 et que les décisions prises par le gouvernement mauricien, notamment la création de la MIC, sont justifiables. Ces mesures, a-t-il précisé, ont grandement aidé à préserver l'emploi, en particulier dans le secteur du tourisme. Au sorti de la pandémie, la MIC est maintenant appelée à jouer un rôle prépondérant dans le développement et la modernisation de Maurice et de son économie. La Banque centrale s'est en effet dotée, à travers la création de la MIC, d'un portefeuille d'investissement local qui cadre avec son mandat de promouvoir un développement économique ordonné et équilibré. Je rappelle que la MIC est une société d'investissement générant des bénéfices, ce qui, in fine, renforce encore davantage le capital et l'indépendance de la Banque centrale. L'orientation de la MIC est et reste la création de richesses pour les Mauriciens. Ainsi, la décision de la Banque de Maurice de conserver sa filiale d'investissement sur le plan local est prise dans l'intérêt suprême du pays. Merci.
Thank you, Honourable Minister. I can see from paragraph 24 of the IMF report that the government of Mauritius has given the undertaking that by June this year, they were supposed to submit to the IMF for consultation a draft bill of the new BOM Act. May I know from the Honourable Minister whether this has been done?
Monsieur le Président, nous travaillons continuellement sur le draft bill. Il est vrai que ce n'est pas encore finalisé, mais que dans les, je peux le dire, dans les semaines à venir, nous allons faire le nécessaire. Je sais que la Banque de Maurice est en train de travailler continuellement, je le dis, directement avec le FMI. Nous, au niveau de l'autorité, nous allons prendre connaissance des dispositions de cette nouvelle loi quand ce sera rédigé. D'accord? Donc, c'est directement, la Banque de Maurice est en train de faire directement avec le FMI. C'est comme cela qu'on a travaillé dans le passé. La Banque de Maurice ne va pas passer par Maurice pour envoyer au FMI, il va envoyer directement.
My second supplementary is with regards to paragraph 22 of the IMF report, wherein the IMF has recommended that the amendments to the new bill should prohibit any future direct financing to non-banks, for example, to the government, as well as it should also prohibit quasi-financial activities, fiscal activities, like the setting up of the MIC, for example. Now, may I know from the Minister whether these amendments are going to cover those aspects and prevent any future financing from the Bank of Mauritius to government?
Monsieur le Président, je vais répondre directement à la question posée par l'honorable membre. Je tiens, avant de répondre à cette question, à repréciser encore une fois le contexte quand on avait fait ce transfert. Ne vous inquiétez pas, je vais vous donner la réponse. Parce que souvent, j'ai remarqué qu'ici, on met souvent en doute ce que nous avons fait en 2020. Nous pouvons ne pas être d'accord, mais je me rappelle très bien qu'à l'époque, on était tous d'accord de la situation où on était en train de se diriger, de la situation économique catastrophique qui s'annonçait devant nous. Aujourd'hui, j'ai vu, nous entendons très bien certaines recommandations par rapport à ce que nous avons fait en 2020. Je tiens à préciser, Monsieur le Président, si vous me le permettez, je vais vous donner quelques chiffres. Vous savez, je suis un économiste, j'aime bien donner quelques chiffres, et après, je vois l'honorable membre, donnez-moi quelques secondes, ça ne va pas prendre beaucoup de temps. Je vais vous répondre à votre question, je sais très bien ce que vous avez répondu, la réponse va être très très simple. Ça va être un oui ou un non, je vais vous dire oui ou non. Mais premièrement, je voudrais parler de cela. On était avec un PIB de 500 milliards en 2018, 511 milliards en 2019, 448 milliards en 2020. Donc, ce qu'on a perdu, on aurait dû être à genoux, avec presque 22% de taux de chômage, une série de faillites qui allait entraîner encore plus de chômage. Maintenant, on est dans la pente ascendante. Nous sommes en train de reprendre. Nous avons fait 480 milliards en 2021. Plus de 20 milliards en dessous de ce qu'on avait fait en 2019. C'est pour 2022 que nous allons pouvoir dépasser le PIB de 2019. Cela veut dire que les 2 dernières années, 2020-2021, ça a été des années de crise. Parce que pour la première fois depuis 40 ans, nous n'avons pas pu dépasser continuellement le PIB qu'on avait fait l'année auparavant. Donc, nous avons utilisé MIC, nous sommes partis vers des politiques non conventionnelles, mais même l'administrateur du FMI reconnaît que nous avons choisi ces politiques pour pouvoir sortir de la crise. Maintenant, pour répondre à votre question, Monsieur l'honorable membre, bien sûr, nous n'allons plus choisir d'adopter des politiques non conventionnelles parce que nous sommes en train de rebuild notre résilience avec la montée de la croissance économique qui va nous permettre de construire et de consolider notre Resilience Fund pour la prochaine crise. Merci, Monsieur le Président. Bien sûr.
You have one more? That would be the last one.
Okay. Now, if the Honourable Minister has said that he's not going in the future to take money from the BOM, but then the IMF report also says that the presence of those 2 deputy governors on the board of the MIC amounts to a conflict of interest, clear conflict of interest. Now, why is the Honourable Minister not taking the appropriate measures to relinquish ownership of the MIC?
Monsieur le Président, encore une fois, nous ici, nous écoutons, nous prenons connaissance des recommandations, mais nous appliquons ce qui nous convient pour le développement économique de Maurice. Nous enlevons, donc vous êtes en train de nous dire d'enlever MIC, de renoncer à MIC. C'est quelque chose que je laisserai le soin à l'honorable membre quand un jour, peut-être à la Saint-Glinglin, quand il sera de nouveau au pouvoir, il pourra à ce moment-là relinquish, il fera une demande au gouverneur. Nous, de ce côté de la Chambre, je laisse la politique monétaire, la politique, le management de la Banque centrale. Ils ont décidé de maintenir, ils maintiennent MIC.
What is happening? You already Minister of Finance? No. So, the question has sufficiently been canvassed. We move to the next question. Honorable Richard Duval.
954.
Mr. Speaker, sir, in reply to Part A of the question, since 1st June 2022 to 21st July 2022, 14,751 persons were tested positive for COVID-19, out of which 12 deaths were attributed to COVID-19. In reply to Part B of the question, concerning additional measures to be taken, the Public Health Unit of my ministry regularly makes situational analysis based on international scenarios and local reports on COVID-19, namely vaccination status of the population, testing capacity, emerging variants, adherence to sanitary measures in force, available treatment, as well as number of cases detected, hospitalization, and deaths. Mr. Speaker, sir, several countries across the world have reduced, if not eliminated, all public and sanitary measures. All these countries are even facing an uprise in the reported number of COVID-19 cases and deaths. However, these countries did not revert back to the previous sanitary precautions. Similarly, in Mauritius, it has been observed that the weekly number of reported positive cases has increased. However, it should be pointed out that hospitalization due to COVID-19 and relative death have not increased. In light of these factors, coupled with a high vaccination status, no additional measures is being envisaged for the time being.
Can the Honourable Minister give a breakdown? How many have been tested with the PCR test and how many with the rapid antigen test?
Mr. Speaker, sir, I will table the information in a weekly basis. On a weekly basis.
Thank you, Mr. Speaker. Honourable Minister, will you please confirm to the House whether, when you're doing the computation of the figures, are you taking into account both PCR tests and antigen tests?
Yes, Mr. Speaker, sir. These figures that I have just given, they are both for the rapid antigen test and the PCR test.
Sean Roy.
Thank you, Mr. Speaker. Sir, can the Honourable Minister inform the House, give further details pertaining to the profile of the patients who passed away during the last 2 months? Thank you.
Yes, Mr. Speaker, sir. During the last 2 months, so as at 25th July 2022, 14 deaths attributed to COVID-19 has been recorded. All were above 60 years of age and with multiple comorbidities. Here I would like to express my sincere and deepest condolences to the families bereaved. Among the 14 deaths recorded, 7 were not vaccinated, 6 were vaccinated, and 1 case is still under investigation.
Thank you. Can the Honourable Minister inform the House the number of persons tested positive from Agaliga during the last 5 days?
Mr. Speaker, so this one, so far I know the figures that I have, it's around about 25. 25 persons have been tested positive in Agaliga, and all of them, if I'm not mistaken, they are all asymptomatic.
Next question, Dano.
Thank you, Mr. President. B955.
Mr. Speaker, sir, the total road network all over the island is estimated at around 2,400 kilometers, out of which some 1,350 kilometers fall under the purview of the Road Development Authority. These roads are listed under the Road Act and the Motorways and Main Road Amendment Regulations. The remaining roads fall under the jurisdiction of the respective local authorities. Mr. Speaker, sir, the road for which the RDA is responsible are classified in 3 categories, namely the motorway, the A roads, and the B roads. The A roads were initially mainly those linking Port Louis to other parts of the island, such as the A1 road linking Port Louis to Saint-Jean, or the A2 road linking the capital to Central Flag. However, with time and with improvement in the road network management, the A roads are those which have better characteristics than B roads in terms of width, horizontal and vertical geometries. As regards the B roads, they are those which usually link important conurbations such as B1 road linking Eben to Réduit or B2 road linking La Louise to Palma and Bosonge. Mr. Speaker, sir, with regard to part A of the question, I'm informed that the number of classified roads are as follows. 3 dual carriage classified motorways, M1, M2, M3, over a total length of about 104 kilometers. 21 roads classified as A roads over a total length of around 242 kilometers, and 174 roads classified as B roads for a total length of some 1,004 kilometers. As regard to part B of the question, I'm advised that the following main technical criteria are considered prior to classifying a road. Firstly, the characteristic of the existing road and the acceptable horizontal and vertical alignment. Secondly, the volume and type of traffic using such road. And thirdly, the level of upgradability of the existing road to A or B with provision of amenities such as footpath and drains, among others. A and B roads generally should have a minimum width of around 6 meters. Thank you, Mr. Speaker, sir.
Thank you, Mr. Speaker, sir. 3 supplementary. Will the Minister consider conducting a survey in order to identify roads that can be included in the list of classified roads?
Mr. Speaker, sir, we have currently with the upgrading, with the amount of work that is being done around the island, the upgrading of several roads, and I should thank the Minister of Finance and the Prime Minister for providing us the required fund. L'île Maurice est un sentier. On est en train de revoir the whole network of road. We have a road master plan coming, for which we will plan not for the 10, 20 years ahead, but we are planning for the 100 years to come. So yes, this is a constant process. We will eventually try to see what are the roads under those very specific criteria so as we can upgrade them. Thank you.
Thank you, Mr. Speaker, sir. Thank you, the Minister, for the good work that he is doing in the constituency and around Mauritius. Can the Minister consider the classification of road Beato, Les Casiennes, and Frédéric Bonnefin?
As the Honourable Member is aware, we are currently upgrading the Beato Avenue, and we have already resurfaced quite some length of the Beato Avenue, from Cupip up to Floréal. This is underway. And where they have the station of the CEB, from there we are trying to enlarge that road because as it is now, it's pretty narrow. But I think once the upgrading is done, it has been widened, it has been resurfaced. Yes, I think given that this can be a bypass, I understand, for those traveling from Lower Plain William toward Cupip. I think, yes, we can eventually consider, but of course under the guidance of my engineers of the ODA.
My last supplementary. We thank the Minister again for all the hard work that he is doing in Cupip. What's your problem? Can I put my question?
Oh, Lee Kuan Yew, sir.
I think I have the floor. I can put my question. Is speed a criteria for classification of A and B road? And if yes, will the Minister consider upgrading the classification of road B6 from Wooton Roundabout to Flag from B road to an A road?
Mr. Speaker, sir, the Honourable Member will appreciate that there are quite a few technical details that we'll need to consider before replying to this, but I promise to personally look into and eventually with his support to do whatever required so as we can see what can be done so as we can upgrade. Thank you.
Thank you. The Honourable Minister mentioned that for a road to be considered as classified, horizontal and vertical geometry is important, and for inclusion as well. Can I ask him whether it will be, otherwise the road is vested in the local authorities. Can I ask him whether from now on, would it be a policy of government for every new road that is being constructed, that RDA will have an overview of those roads so as to have them included as a classified road?
No, Mr. Speaker, sir. I think we need to have, we do respect our local authorities, and we do also give also the chance to work and assumer les responsabilités vis-à-vis le pays. This is purely undermining the competencies at the level of our local authorities. We have already so much on our plate, and we are constructing new roads, like, for instance, I just replied to Honorable Boda, the link road from the center of the island to the west. So these are also being taken care by the RDA. RDA cannot now come and take the road all over the island. Eventually, maybe, if we have the required finance, we can. But this entails much more than just taking the road, upgrading them. I think each component of different authorities need to take their responsibility for a proper road network in the island. Thank you.
B956, please.
Speaker, sir, I'm informed by the Mauritius Tourism Promotion Authority that an amount of £1.5 million has been disbursed to the Liverpool Football Club to date. As regards Part A of the question, the contract is valid until the 30th June of 2024, or the expiry of the season 2023-2024, whichever comes later. Mr. Speaker, sir, insofar as the last part of the question is concerned, the House may wish to note that since the contract is valid until the 30th June 2024, or the expiry of season 2023-2024, it is premature at this stage to consider renewing the said contract.
Monsieur le Président, et par rapport à la somme qui a été dépensée, par rapport au contrat qui a été signé entre Liverpool Football Club et la MTPA, peut-on savoir, durant les années passées, ce que le pays a bénéficié par rapport à cette somme qui a été dépensée, par rapport au contrat qui a été signé entre Liverpool Football Club et la MTPA?
Mr. Speaker, sir, honourable member will appreciate that I might not have these information, and kindly requesting if question could be put to the substantive minister for more information.
J'ai un certain nombre de questions, encore peut-être 2 questions, mais si l'honorable ministre n'est pas en mesure de répondre, je préfère ne pas les poser.
Bon, allez-y, si vous le souhaitez. Si j'ai les éléments de réponse, bien sûr.
Donc, je vais demander au ministre, par rapport à la fiche publicitaire qui a été visible à Anfield Road lors des matchs de Liverpool Football Club à domicile, effectivement, peut-on savoir combien de fois par match cette affiche a été visible et pendant combien de secondes par match? Vu la somme qui a été dépensée, peut-on savoir si cela nous a permis quand même d'avoir un retour sur l'investissement?
Mr. Speaker, sir, what I can state to the House is that the Liverpool Football Club, with a fan base of 451 million supporters around the world, some 18 million of them of high net worth individual, can be targeted as our main tourist market. We're talking about a large population of supporters when it comes to Liverpool Football Club. And out of those 18 million supporters, 36% are estimated to choose a brand that partner with Liverpool Football Club for their holidays and for investment opportunities. I can go on with a list of other advantages or statistics that can prove that il y a un retour sur l'investissement par rapport à ce contrat qu'on a conclu avec Liverpool Football Club. Mr. Speaker, sir.
Mr. Speaker, sir. So the Minister confirmed that 1.5 million of pounds has been spent already, paid. Can I know the terms and schedules of payment regarding this contract up to 2024?
So the first payment, as I mentioned, was 1.5 million pounds upon signature of the contract in July 2020. And the second payment of 2.5 million pounds is due in July 2022. Invoice for the second payment was submitted on the 20th of July 2022 to the Ministry of Finance for consideration and payment to be effected under the National Resilience Fund expected by the end of July 2022. And the third payment, of course, 2.5 million pounds due in July 2023.
Last question.
Thank you. The Honourable Minister has just mentioned the branding Liverpool Football Club. Doesn't he agree that, on the one hand, if he associates Mauritius with Liverpool, that will definitely put off all supporters who do not support Liverpool, and therefore Mauritius should be adopting a neutral stand rather than identify itself to Liverpool?
We might seek, Mr. Speaker, sir, we might seek recommendations from honourable member of other teams that we might conclude agreements. But the statistics show that, and with the performance of the Liverpool Football Club during the past few seasons, there can be no other better team to conclude for our marketing, Mr. Speaker, sir.
Next question, MP Kiran.
B957, please.
Mr. Speaker, sir, in reply to part A of the question, I'm informed that as of 20th July 2022, 11,070 persons had already been administered a second booster dose. Mr. Speaker, sir, in reply to part B of the question, I wish to reassure the House that the vaccination campaign for the second booster dose is still ongoing at 16 different sites. Persons aged 59 years and above, as well as those at risk and suffering from comorbidities, are recommended to get their booster dose of COVID-19 vaccine so as to further protect them, especially during the winter season. Mr. Speaker, sir, in reply to part C of the question, I'm informed that as of 21st July 2022, there was a total of 792,386 COVID-19 vaccines in stock, out of which 68,296 doses of Sinopharm vaccines, out of which 8,296 doses will expire in June 2023 and 60,000 doses in August 2023. Second is the 115,250 doses of Johnson & Johnson, out of which 4,630 doses will expire in December 2022, January 2023, and 110,620 doses in August 2023. Third is 298,440 doses of Pfizer, out of which 2,400 doses will expire in August 2022, and 203,580 doses in end of July 2022, and 92,460 doses in September 2022. Fourth, 119,520 doses of Moderna vaccines, out of which 500 doses will expire in August 2022, and 119,020 doses will expire in August 2022. Now, fifth is 190,880 doses of pediatric Pfizer vaccine, out of which 1,930 doses will expire in August-September 2022, and 180,950 doses in September 2022. Mr. Speaker, sir, in regard to part D of the question, I have already elaborated on the recent increase of COVID-19 positive cases and factors considered for any sanitary measures in my reply to PQB 954.
Nous constatons qu'il y a une recrudescence de cas de la COVID-19 en ce moment. Peut-on savoir de l'honorable ministre quelles sont les mesures que son ministère compte prendre afin d'inciter plus de Mauriciens à se faire administrer la deuxième booster dose?
Mr. Speaker, sir, as per the recommendation of the vaccination committee, as at now, the second booster dose is recommended for those above 60 years and those with comorbidities. So this has been a campaign since the last 3-4 months to recommend those who are eligible for the second dose to get vaccinated. So now we are in a situation where you have many of the above 60 or with comorbidities who have been infected. And now, per the definition of those who are infected, they are eligible for a second booster dose after 4 months or within 6 months. So we have to see this aspect of those who have already been infected recently, and then they have already done the booster dose. So we will need some time for them to get their second booster dose.
Dire si son ministère a procédé à une certaine évaluation du coût des vaccins qui vont être expirés bientôt, ou si son ministère envisage de remettre à certains pays qui sont en difficulté, comme il l'avait préconisé à un certain moment. Surtout, là, je vois qu'il y a plus de 60 000 vaccins de Sinopharm, entre autres, qu'on n'utilise plus.
Yes, Mr. Speaker, sir. So already the ministry has given the donation to other countries. I will just give a brief outline that the government has already donated to Zimbabwe 60,000 doses in November last year, Rwanda 50,000 doses in November, Tanzania 150,000 doses, Uganda 150, and Namibia 150,000 doses. So already this process of donation is ongoing. So we have already, the offer has already been made through the Ministry of Foreign Affairs. So obviously once country will accept those vaccines, we are going to proceed for the donation.
In terms of preparedness by the ministry, in light of the recent increase, will the ministry consider to provide the health centers with vaccination facility? I mean, all the health centers, because now it is centralized in hospital, in certain health centers. Will you consider to extend it to in the regions?
Yes, Mr. Speaker, sir. Obviously, so because of the demand has gone down, now for the last 1 month, so approximately 200 persons are coming up to the vaccination centers for vaccination. That's why we have again centralized the vaccination center. Now, in the light of the coming vaccination committee recommendation, if ever this vaccination will be eligible to other categories of those we can get them their second booster dose, obviously we'll work again upon the vaccination team, whether we should be more focused on having mobile teams going to the different regions where for example, now that the centres communautaires are all open, so if we have the old age association, and from them we can do the vaccination, targeted one that would be appropriate, especially for the elderly. So the ministry is working this with the Ministry of Social Security.
Can the minister inform us with the recent cases in Agaliga, whether there are sufficient vaccines in Agaliga? What is the minister is planning, his ministry, with regard to Agaliga?
Yes, Mr. Speaker. In fact, for Agaliga, the vaccination, we have already conducted the vaccination in September, October last year with the booster dose, all they have. So far, I remember there are some 1,200 workers in Agaliga, plus 3,000 Agalians. So 300 Agalians. So we've already conducted vaccination for around 1,300 Agalians, and the workers, they have already been vaccinated. So, and then we do have the preparation plan, how to do the testing, what do we do in case we got emergencies, how many medical teams are already posted over there for the testing and for the treatment as well.
MP Mahmoud.
B958.
Yes, Mr. Speaker, sir, all public hospitals have a catering unit which provide meals to patients who are admitted thereat. Catering units operate from 6:30 in the morning to 17:30 hours on a daily basis, and all inpatients are provided with breakfast, lunch, and dinner. Meals are prepared based on dietary recommendations from the chief nutritionist. In addition, meals are also provided to officers working after normal working hours and who are entitled same. Mr. Speaker, sir, I'm informed that food wastage in public hospitals is mainly due to the following reasons. First, during visiting hours, relatives bring along meals for inpatients, and thus meals which have already been ordered and prepared by the catering unit are not eaten by the patients. Second, it's common that a patient's condition may suddenly deteriorate, requiring the treating doctor to keep the patient fasting for medical reasons, for diagnostic tests, or even surgical procedures. Third, upon improvement of a patient's condition following treatment administration, the treating doctor discharges the patient prior to meal service. Fourth, many times meals prepared for patients are not eaten as sick patients often lose appetite, leading to a considerable amount of leftover foods. Fifth, some patients are often not willing to receive hospital meals at the time of service, despite requests to be provided with same during the preparation of diet sheet by ward managers and charge nurses. Mr. Speaker, sir, reducing food wastage is on the agenda of my ministry, given the associated financial and environmental impacts. A number of measures have been put in place by my ministry to ensure minimal food wastage at the level of all public hospitals. These measures are as follows: a diet sheet comprising the number of patients in a specific ward, their preferences for meal, number of meals required depending on admission and discharge, types of meals depending on health status of patient, and any other dietary requirement is submitted on a daily basis to the catering unit to ensure that the number of meals prepared strictly meet with the requirements of the patients in each ward. All meals are prepared and distributed according to proportion sizes recommended by the chief nutritionist. For example, the portion of chicken or fish per meal for one patient is around 150 grams. All nursing staff at the level of wards are fully aware of the dietary requirements and choices of each patient, and the number of meals served is closely monitored by the nursing staff, who also encourage patients as far as possible to finish their meals. All staff working after normal working hours and who are entitled to meals are required to fill in a meal request form, which is certified by the head of department prior to obtaining their meal. Mr. Speaker, sir, in spite of and improve the quality of each food pack will comprise a container divided into 4 to 5 compartments for the different foods. The food packs will be conveyed in a heated trolleys from the catering unit of the hospital to the wards, and patients can consume their meals as and when they feel hungry. By implementing this novel measure, my ministry will encourage patients to consume hospital meals, thereby bringing food wastage in public hospitals to a minimum. Thank you.
Can the Honourable Minister state whether normally patients are being asked in the morning if they would opt for meal brought by close one during visiting hours? Is there a protocol? Is there something being asked in the morning?
Yes, Mr. Speaker, sir, as I've already stated it in my reply. So the nursing officers at the level of wards, they are fully aware that the number of meals that has to be prepared for each ward. But there are factors that their patients may be discharged or patients. So there are factors that will not be able to assess it in the morning. But that exercise of the number of meals to be prepared based on the number of admissions that...
Thank you. Will the measures that the Honourable Minister will take henceforth cater for the fact that by the time the meal is served at 5 p.m. after visiting hours, up to normal dinner time of most Mauritians, 7 to 8 p.m., the food gets cold and hence not appealing for people to eat, an issue which I have had raised with him in the past. Would that cater for this issue?
Yes, so that's why, Mr. Speaker, sir, we are coming with the pack food. So the pack food will be already packed in the catering unit, and that it will be kept in a, you call that, in a place where you can keep in heated trolleys. So these food can be, the patient can, at his time of convenience, have this food. So this will, again, reduce the wastage of food. So this will be implemented, hopefully by end of this year or beginning of this year. And we are envisaging to implement this on a pilot basis. For example, we'll start it for wards, the children ward first, and with the post-maternity ward. We understand that, women who have delivered and how good it would be to have a good packed meal. So this is what we are working for, and hopefully by end of this year, beginning next year, we can start it by these wards first, the children ward and the post-maternity ward, how we call it.
Next, you have one.
Thank you very much, sir. Ask the Minister whether the services to provide packed food will be contracted out, or whether the services will be contracted out or delivered by the delivered in-house.
Yes, Mr. Speaker, says the services will be delivered by the catering unit, but they will require a training first. So the MIH will provide training to the staff working in the catering unit how to do the packing of these food so that this can be distributed to patients, and it will be done by the catering unit itself.
B959, please.
Yeah. Mr. Speaker, sir, yes, I'm informed that there were 7 cases of healthcare personnel found drunk while on duty for the last 3 years. There are 3 cases at G2 Hospital, 1 case at Victoria Hospital, 1 case at Nehru Hospital, and 2 cases at Sasiusagar Amgulam National Hospital in the north. So at G2 Hospital, 1 ambulance driver was involved in a case of road accident, and the matter was reported to the police. The ambulance driver was sentenced to pay a fine, and he was disqualified to drive all types of motor vehicles. The officer has already retired from the service. 1 health records clerk was found drunk on duty, and the case was reported to the senior health records officers. The health records clerk is now regular at work, and there is no adverse report against him. The third case is a doctor who was scheduled to work at Quartier Militaire Area Health Center. He arrived late at his place of work and was reported of smelling of alcohol. The incident was reported to the duty manager, and an inquiry is ongoing in this case. At Victoria Hospital, there is one case of an ambulance driver who attended duty under the influence of alcohol. A letter of caution has been issued by the regional health director to the ambulance driver. At Jawaharlal Nehru Hospital, a complaint was received against one ambulance driver who was driving under the influence of alcohol. In this context, a board of inquiry was set up at the level of the regional hospital, and it was recommended that the conduct of the ambulance driver be monitored by the supervisor, operation support services, and any shortcomings should be reported to the HR section of Nehru Hospital for appropriate actions. At SSR Hospital, there was one healthcare assistant who was drunk during his night duty, and an inquiry committee has been set up to look into the matter. There was also one general worker who was under the influence of alcohol, and a letter was issued against him. Thank you.
The Minister just mentioned about a recent case of a doctor who worked at Quartier Militaire and who was suspected of being drunk. Can I ask the Honourable Minister reasons as to why he was not asked to take time off until a proper inquiry has been conducted and appropriate measures be taken in the interest of safety of himself and the public, but rather he has been transferred to G2 Hospital to work in a high-risk department such as surgery?
Mr. Speaker, sir, so there is an inquiry on this patient. So I'm not in a position at this time of inquiry to provide further information about this doctor who has been found, drunk or smell of alcohol at one place of work. So we'll wait for the report. At the same time, so whether this is in order to take an action before a report will come up, that is the human resource section has to give those elements whether this can be done or not can be done. But at this time, I don't have this information, and I'm not in a position to comment on this where an inquiry is ongoing.
Thank you. Alcoholism is a serious condition that affects many professionals in all walks of life. Thus, his ministry has a psycho-counseling and support unit for its medical and paramedical employees, and if not, whether he will consider setting one up.
Mr. Speaker, sir, well, I have to reply to this question. This will apply to all public officers, even to officers working in the private sector, whether somebody who is, having, a problem with alcohol, we call it harmful drinking. How do we first assess this harmful drinking, and how we should implement some, any recommendation or any action to be taken on this? For the time being, it's very difficult for me to comment on this issue.
The minister himself being a doctor, can I ask him, during on-call hours, can the minister enlighten us as to who, during emergency hours, on-call between 4 p.m. till the next morning 9 a.m., who can prevent a drunken doctor from performing surgery? Because many a times, the whistleblower finds himself at the receiving end of some punitive action by people around, and there has been cases before. Thank you.
Mr. Speaker, sir, honorable member being a surgeon himself, so he should at least provide me with some details of those drunken surgeons who do take the risk of doing an operation, and that he should have, give me this information. Obviously, as a psychiatrist, I will be able to look after that. So if
Next question.
B960.
Yeah. So, Mr. Speaker, sir, as per the last National Nutrition Survey carried out in 2012, 9.9% of children aged between 5 to 11 years were found to be obese. With regard to children aged 13 to 17 years, the global school-based survey carried out in 2017 in collaboration with Centers for Disease Control and Prevention has revealed that 9.1% of adolescents were obese and another 15.7% were overweight. I wish to inform the House that my ministry is currently carrying out the National Nutrition Survey 2022 from 23rd July to 10th August 2022. So the main objective of this survey is to study food consumption patterns and assess the nutritional status of the population with a view to address diet and nutrition-related health problems and non-communicable diseases in the country. Children 5 to 11 years old will be included in this survey. With regard to part A of the question, information is available for type 1 diabetes children who are being treated in our government hospitals and the number of new cases of type 1 diabetes diagnosed among children and adolescents for the period 2014 till June 2022 is 121. Mr. Speaker, sir, with regard to part B of the question, I wish to inform the House that saturated fat in specific foods is regulated in the current Food Regulation 1999. It is worth to note that the sale of food on premises of educational institutions, Regulations 2009, Schedule Regulation 3, already make provision for food which may be sold on the institution campus which is in force as from 2010. I'm sorry. Furthermore, I wish to highlight that in the forthcoming food regulations under the Food Act, which are under preparation, trans fatty acids will also be regulated at not more than 1% on a fat weight basis. Salt will also be regulated in the new food regulation. Excuse me. Moreover, a nutrient profile model in Mauritius is underway. So this model will be used as a tool for banning of advertising of high-fat, salt, and sugar food or drink products directed towards children. The nutrient profile is a scientific method for categorizing food and beverage items according to their nutritional composition. It provides a method of differentiating between foods and non-alcoholic beverages that are admissible in a healthy diet from those that are unhealthy, notably those foods that may contribute to consumption of excess energy, saturated fats, trans fats, sugars, and salt. The World Health Organization has adopted nutrient profiling as a useful tool to define foods whose marketing should be restricted as part of the implementation of the recommendations endorsed by the World Health Assembly on the marketing of foods to children. A regional nutrient profile model has already been developed for the African countries by WHO. technical assistance of the World Health Organization has been enlisted for the Mauritius nutrient profile model that is underway. Thank you, Mr. Speaker.
Merci. Suite à la réponse de l'honorable ministre, on peut conclure que le taux d'enfants en situation de surpoids et d'obésité est alarmant. Et c'est un fait que de manger sain et équilibré coûte plus cher et de surcroît, le contexte actuel de la diminution du pouvoir d'achat accentue le problème de malbouffe. Quelle est donc la stratégie de son ministère pour encourager l'alimentation saine et aussi pour décourager les mauvaises habitudes alimentaires, particulièrement chez les enfants?
Yes, Mr. Speaker, sir. We are all concerned with obesity, with the pattern on food. That's why in my reply, I've stated what we are doing, that is the survey on the nutrition survey. This is very important, National Nutrition Survey. And also in the Food Act that will be coming into force and how we can limit, especially foods that I've mentioned, fats with trans fats and all that, how to limit it, especially for children. So all those will be coming soon, and also with the Food Standard Agency, where all this information will be given to anybody, whichever food you wish to have, you can always get the information there. So also this nutrient profile model for Mauritius, it's very important to have this so that we can know what is the nutrient profile for any individual. So all these are actions already taken. Now, what I will probably request all members of this House, how do we promote healthy eating and healthy habits? So we all have to be role model in promoting such activities. The Prime Minister is doing it through regularly participating. Yes, the Prime Minister is doing it. I will maintain for regularly participating in physical activities, which is very important so that we can, at the same time, healthy eating with a healthy lifestyle, promotion of activities. I will also welcome you all. We all participate so that we can also send the right signals, the right information to the population, because only by having regulations, information, but not acting as role model, we will keep on having the percentage of obesity, especially in the young generation, it will keep on rising.
Permettez-moi d'abord faire une suggestion et puis je vais poser ma deuxième question supplémentaire. J'aimerais suggérer à l'honorable ministre que les produits emballés qui sont riches en sucre, sel et gras saturés soient munis d'étiquettes de mise en garde pour aider les consommateurs à réaliser le choix alimentaire plus conscient. Ça, c'est une suggestion. Et ma deuxième question est de demander à l'honorable ministre s'il y a eu une étude pour connaître le fardeau économique sur le système de santé relatif au coût des maladies associées aux habitudes alimentaires malsaines.
Mr. Speaker, sir. Thank you very much. This is a very valid suggestion, especially to have in the, in all the food packets that we have, to have already showcase, to highlight, especially the amount of sugars or salt in there. So this is, yes, this will be coming in the food regulations that we will be coming up soon, because the consultant's still working on that. And concerning the second part of your question,
une étude sur le fardeau économique sur le système de santé relatif au coût des maladies associées aux habitudes alimentaires malsaines.
So, Mr. Speaker, sir, so we will be soon receiving the NCD, the Non-Communicable Disease Survey. So we'll see what is the report in that NCD survey, because this NCD survey has been done recently, and the report is expected in the coming days or probably by next week. So based on this NCD surveys, and then with this nutrition survey, we can plan, we can see what is the different strategies that we have to adopt, especially of what you are mentioning. You're perfectly right.
Thank you, Mr. Speaker, sir. In his reply, the Honourable Minister mentioned about healthy lifestyle, and he even mentioned about the physical activities. For a fact, we know that the Minister of Sports is laying much emphasis on what is called physical activities, but can he inform the House whether his ministry is coming forward with maybe some kind of an action plan, especially for children, in order to promote physical activities? Thank you.
Yes, Mr. Speaker, sir. So let me first congratulate the Minister of Sports. That's through the Mauritius Sports Council, in collaboration with the Ministry of Education and the Ministry of Health. We've been working together, especially to foster this culture of community sports and physical activity, and especially for, promoting sports, especially for everybody, even for patients. Recently, Active Mauritius have come up with a new design, that is prescription of a physical activity for patients suffering from NCD diseases. So this has recently been launched, I think it's 6 months, again on a pilot basis, to see how physical activity can promote in the well-being, especially instead of depending only on medication when it concerns for non-communicable diseases. So all these sensitization program concerning even the policy at the policy level, so it's been worked out together with the Mauritius Sports Council, the Ministry of Health, and the Ministry of Education.
Next question.
B961.
So, Mr. Speaker, sir, in reply to part A of the question, I wish to point out that the information pertaining to the stock of the and expiry dates of COVID-19 vaccines has already been addressed in PQB 957. Now, in regard to part B of the question, Mr. Speaker, sir, I'm informed that in accordance with the commitment agreement signed with the COVAX facility, there is an outstanding balance of 406,400 doses of COVID-19 vaccines. A request was made in March 2022 for cancellation of the outstanding balance, and various proposals were submitted by the COVAX facility for consideration. First, purchase of all outstanding doses, which would amount to some USD 3,454,400 USD. Second, substitute out the products that we are to receive for different available products. And third, terminate the commitment agreement in return for payment of an exit price. So, Mr. Speaker, sir, following perusal of the above proposals, our mission in Geneva was requested to liaise with the COVAX facility to consider providing us with other vaccines or other pharmaceutical products in lieu of the COVID-19 vaccines. However, on 7th July 2022, COVAX facility has now informed that option 2, that is substitution of products, would no longer be applicable. The other two proposals are being considered by the Vaccination Coordination Committee in consultation with the State Law Office as to the way forward.
Honourable Minister, with regards to the expired vaccine, which will be expired in August, July and August, we have more than 400,000 doses which will be expired. Can we know the cost of these vaccines, especially if you can get the cost of Pfizer vaccines?
Mr. Speaker, sir, for the other vaccines, if I will just go back to what has been said, so the Moderna vaccines was a donation from the, just give me, yes. So this was, the Moderna vaccine was donated by the French Ministry of Health. There are the Pfizer vaccine also donated by the US government, that is the pediatric Pfizer vaccine, and it's only the Pfizer vaccine that we have. We have purchased these vaccines. So I don't have the information for the cost price, but I'm going to table this information. But as for those vaccines that we have, we are now in stock, so I have to compile the figures and will table that information.
Honourable Minister, thank you. Is it true that the COVAX facilities inform the ministry, even if we don't take delivery of the 406,000 doses, we will have to bear the costs?
Mr. Speaker, sir, I've already said that there were 3 proposals made by the COVAX facility. So one is to purchase out the outstanding doses, and the other one to terminate the commitment agreement in return for a payment of an exit price of USD 812,800. So these are the 2 that we are going to take a decision, which one we are going to take, which one we will take, and then we'll go ahead. So it's not a question of that we don't have any agreement with COVAX facility. And our mission in Geneva is working on that to see what, if ever, we can have another option. Yeah.
Honourable Minister, despite we have 300,000 doses of Pfizer, why we restrict the age limit to 40 years plus when we have such stocks of Pfizer vaccines?
Yeah. So we are waiting for the recommendation of the vaccination committee. Most likely we will be having the vaccination committee, because the vaccination committee is also getting the information from WHO, through other countries, how they are managing, what are the recommendations for a 4th dose, especially in a context where now we've got many people being already exposed to the to COVID-19 or to the variant. So let's get with the recommendation of the vaccination committee, and then surely the ministry will abide accordingly.
B962, please.
Mr. Speaker, sir, let me at the outset point out that Section 114 of the Workers' Rights Act, which deals with violence at work, provides for, amongst others, that no person shall harass a worker sexually or otherwise in the course of or as a result of his work. And under the same section, that is 114, harassment is defined as including any unwarranted conduct towards worker, whether verbal, non-verbal, visual, psychological, or physical, based on, amongst others, age, sex, and gender, which occurs in circumstances where a reasonable person would consider the conduct as harassment of a worker. Furthermore, it is also provided that any worker, any person who is convicted under this section is liable to a fine not exceeding 100,000 rupees and to imprisonment for a term not exceeding 5 years. Mr. Speaker, sir, I am informed that representations have been received at my ministry as follows. On the 1st of April 2022, one secretary of Mrs. HT registered a case of sexual harassment at the QPIP Labour Office against Mr. DN, Human Resource and Administrative Manager of the Group of Casinos falling under the State Investment Corporation Limited, including the Casino de Maurice. A full statement was recorded from her on the same day for investigation. On the 7th of April 2022, the Secretary informed the Labour Office over the phone that she had also reported her complaint of harassment to the police on 5th of April 2022. She was accordingly requested to call at QPIP Labour Office on the 8th of April 2022 to confirm her stand in writing. As she did not attend the Labour Office on the 8th of April 2022, she was convened for 20th of April 2022 by way of a registered letter. On that date, she attended the QPIP Labour Office and gave a statement confirming that she had also registered a complaint of sexual harassment on the 5th of April 2022 at QPIP Police Station. She further stated that Mr. DN was arrested on the 7th of April this year and was released on bail on the same day. In the statement given to the QPIP Labour Office on the 20th of April, she also informed that the police recorded a statement from her and from her witness on 14th of April. She further indicated that Mr. DN has been suspended from work with effect from the 16th of April this year. In view of the fact that the complainant had also referred the case to the police on her own free will, the Labour Office of QPIP wrote to the police on 3 occasions, that is, on the 27th of April, 17th of May, and 22nd of June to inquire into the status of the case. Mr. Speaker, sir, I am further informed that on the 4th of April 2022, 2 cleaners, namely Mrs. WB and Mrs. PB of Casino de Maurice, called at QPIP Labour Office to register complaints of sexual harassment against Mr. DN. They, however, informed the Labour Office in a statement recorded on the same day that they had already retained the services of counsel to proceed further with their case. They accordingly opted to withdraw their complaint lodged before the QPIP Labour Office. Mr. Speaker, sir, regarding the case of Mrs. HT, an inquiry carried out on the 9th of May this year by the officers of QPIP Labour Office at the Casino de Maurice revealed that Mr. DN has been suspended from work pending the completion of an internal inquiry being carried out by an independent lawyer appointed by the SIC. I am informed that as to date, Mr. DN is still suspended from work. Mr. Speaker, sir, on the 1st of July 2022, officers of my ministry called at QPIP Police Station where they were informed that the above 3 employees had registered cases of sexual harassment against Mr. DN, and statements from the plaintiffs were recorded by the police. They were also informed that Mr. DN was consequently arrested on the 7th of April this year and released on bail on the same day. The officers of my ministry were further informed that the inquiry in respect of the 3 cases has been completed and the matter would be referred to the Director of Public Prosecution for advice. Mr. Speaker, sir, on the 1st of July 2022 itself, the 3 employees called at the QPIP Labour Office and in a written statement informed that they would await the DPP's stand on this matter and the intervention of the Labour Office would be sought should the need arise. On the 14th of July 2022, officers of my ministry contacted the QPIP police station again and were informed that the 3 cases have already been referred to the DPP on the 6th of July 2022 for advice. Mr. Speaker, sir, regarding whether the complainants have made any representation to my ministry to the effect that they are subjected to undue pressure, including insulting comments and foul language, I am informed of the following. In a letter dated 9th of June 2022, received at my ministry on Friday, 10th of June, and co-signed by the 2 cleaners, complaints were made to the effect that 1, Mr. VB, recently promoted in the maintenance department, was continuously harassing them, and the level of harassment increased after they had lodged the criminal case against Mr. DN at QPIP police station on the 5th of April. And in the same letter, one of the 2 cleaners complained that she got a punitive transfer from Casino de Maurice, QPIP, to Le Grand Casino du Domaine Paille, while the other cleaner stated that new working hours from 9 to 17 were being imposed on her as from June 2022. And this was causing hardship to her, and as she had to take bus to travel back home in the evening. Previously, she was working, her working hours were from 7 a.m. to 1500 hours. Mr. Speaker, sir, on Monday, 13th of June 2022, the new cases reported by both employees were raised with the management of SIC Limited, and an appointment was confirmed with the latter on the 17th of June 2022 to inquire into the matter. On the 17th of June 2022, in the course of a meeting my officers had with the management of Sugar Investment Corporation Limited, my officers were informed that remedial action has been taken in both cases, that is, in the case of Mr. WB, who was then posted back to Casino de Maurice at QPIP, and the working hours of Mrs. PB was reverted back as it were previously. Furthermore, a commitment was taken by the management to change the reporting line of both employees. As a follow-up to the commitment taken by the management of the SIC, my ministry contacted both employees on the 30th of June 2022, and both confirmed that necessary remedial actions have been taken. In addition, it has also been confirmed that both cleaners are no longer reporting to Mr. VB since 1st of July. My ministry is closely monitoring the situation. Mr. Speaker, sir, I am also informed that since then my ministry has received no other complaint from either Mrs. HT or Mrs. WB or Mrs. PB of the Casino de Maurice as regard to undue pressure, insulting comments, and foul language. Mr. Speaker, sir, let me reassure the House and the honourable member that my ministry is fully committed to providing all the necessary support to the alleged victims of harassment, and will not condone in any manner whatsoever such wrongful act and doing towards any of the workers of Casino de Maurice.
Monsieur le Président, d'après les informations qui me sont parvenues, ce n'est pas la première fois que le dénommé DN se retrouve au centre d'un scandale de la sorte impliquant des employés du casino. De ce fait, l'honorable ministre peut-il nous dire si, concernant ces dames qui ont subi des agressions sexuelles, verbales, par la suite par certains employés proches de DN, est-ce que ces personnes, ces dames, ont reçu ou reçoivent un soutien psychologique de façon à les permettre de continuer à exercer leur travail dans des conditions plus ou moins sereines?
Yes, Mr. Speaker, sir, I've just mentioned it in my reply that my officers are monitoring the situation and are in constant communication with the management to ensure that the workers are being properly treated.
Afin de protéger l'ensemble des employés féminins du Casino de Maurice, et aussi pour mettre fin à toutes les formes de pression et d'agression verbale, ne serait-il pas plus sage que le Casino de Maurice prenne les mesures qui s'imposent, c'est-à-dire mettre fin au contrat de DN?
Unfortunately, Mr. Speaker, sir, I cannot speak on behalf of the management of SIC. This is a decision which they will have to take.
The table has been advised that PQB 972, B985, B981, B965, B991, B969, B973, B984 have been withdrawn. Time is over by 3 minutes.
Motion.
Mr. Speaker, sir,
I move that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10.
Question is seconded. The question is that all the business on today's order paper be exempted from the provisions of paragraph 2 of Standing Order 10. Those in favor say aye. Those against say no. The ayes have it.
Statement by Ministers, none.
Honorable members, I name the Honorable Shakil Mohammed under Standing Order 48 for disregarding the authority of the Chair and for persistently and willfully obstructing the business of the Assembly by abusing its rules.
Mr. Speaker, sir, in view of your decision to name the Honorable Shakil Mohammed, I beg under Standing Order 17(3) to take the time of the House for urgent business.
The question is that the Honorable Prime Minister be allowed under Standing Order 17(3) to take the time of the House for urgent business. Those in favor say aye, those against say no. Ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29(1) to present a motion without notice.
The question is that the Honorable Prime Minister be allowed under Standing Order 29(1) to move a motion without notice. Those in favor say aye, those against say no. Ayes have it.
Speaker, sir, in view of your decision to name the Honorable Shakil Mohammed, I beg to move that the Honorable Shakil Mohammed be suspended from the service of the Assembly for today's sitting and the next 5 sittings unless apologies are tendered to the House.
Seconded.
Seconded.
The question is that the Honorable Shakil Mohammed be suspended from the service of the Assembly for today's sitting and the next 5 sittings unless apologies are tendered to the House. Those in favor say aye, those against say no. The ayes have it. Honorable members, I name the Honorable Dr. Mahen Ganga Prasad under Standing Order 48 for disregarding the authority of the Chair and for persistently and willfully obstructing the business of the Assembly by abusing its rules.
Speaker, sir, in view of your decision to name the Honorable Dr. Mahen Ganga Prasad, I beg under Standing Order 17(3) to take the time of the House for urgent business.
Question is that the Honorable Prime Minister be allowed under Standing Order 17(3) to take the time of the House for urgent business. Those in favor say aye, those against say no.
Aye.
Ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29(1) to present a motion without notice.
Seconded.
The question is that the Honorable Prime Minister be allowed under Standing Order 29(1) to move a motion without notice. Those in favor say aye, those against say no.
Aye.
Ayes have it.
Mr. Speaker, sir, in view of your decision to name the Honorable Dr. Mahen Ganga Prasad, I beg to move that the Honorable Dr. Mahen Ganga Prasad be suspended from the service of the Assembly for today's sitting and the next 4 sittings unless apologies are tendered to the House.
Seconded. The question is that the Honorable Dr. Mahen Ganga Prasad be suspended from the service of the Assembly for today's sitting and the next 4 sittings unless apologies are tendered to the House. Those in favor say aye, those against say no. Ayes have it. Honorable members, I name the Honorable Patrick Gervais Asivaden under Standing Order 48 for disregarding the authority of the Chair and for persistently and willfully obstructing the business of the House of the Assembly by abusing its rules.
Speaker, sir, in view of your decision to name the Honorable Patrick Gervais Asiavaden, I beg under Standing Order 17(3) to take the time of the House for urgent business.
Seconded.
The question is that the Honorable Prime Minister be allowed under Standing Order 17(3) to take the time of the House for urgent business. Those in favor say aye, those against say no.
Aye.
Ayes have it.
Mr. Speaker, sir, having obtained your permission, I beg to move under Standing Order 29.1 to present a motion without notice.
Seconded.
The question is that the Honorable Prime Minister be allowed, as in the Standing Order 29.1, to move a motion without notice. Those in favour say aye, those against say no.
Aye. Mr. Speaker, sir, in view of your decision to name the Honourable Patrick Gervais Asiavaden, I beg to move that the Honourable Patrick Gervais Asiavaden be suspended from the service of the Assembly for today's sitting and the next 4 sittings unless apologies are tendered to the House.
Seconded.
The question is that the Honorable Patrick Gervais Asiavaden be suspended from the service of the Assembly for today's sitting and the next 4 sittings unless apologies are tendered to the House. Those in favour say aye, those against say no. Aye. The ayes have it.
Public Bill, first reading.
Mr. Speaker, sir, I move that the Finance Bill 2022, number 14 of 2022, be read the first time.
Seconded.
Public Bill, second reading.
Public Bill, next speaker.
Mr. Speaker, sir, thank you for the opportunity to contribute to the debate on this important bill. Mr. Speaker, sir, at the very outset, let me congratulate the Honourable Prime Minister for bringing this bill to the House and for the commendable work and effort that he is putting in to improve the legal framework in our island and our national security. The main object of this bill is to consolidate and strengthen the law with regard to the admission and stay of non-citizens in Mauritius. The Immigration Act 1970 has served its time after going through multiple amendments to cater for the ever-changing immigration scene. And it has now become necessary to enact a more simplified and efficient immigration legislation. Mr. Speaker, sir, as a country, we welcome the benefits that migrants bring to our industries, educational institutions, and communities. We know that most migrants are here lawfully and benefit our country, but some are not. They enter the country illegally, overstay their permission to be here, work illegally, undercutting the resident labor market, contribute to overcrowded housing, and damage social cohesion. It is true that the bad apple immigration story often drown out the positive ones. The challenge for both government and parliament is to implement policies which strike the right balance, keeping the door open to those who have something to contribute while maintaining a firm response against those who abuse our hospitality. Immigration is an issue of significant concern to the public. This government remains committed to reducing net migration. We have tightened the immigration routes where abuse was rife, strengthened the system of granting student permission to enter or stay in Mauritius, reformed the investment route, and so on. These reforms are not just reducing volumes. Rather, they have changed the character of migration to Mauritius. This bill will not undermine those important achievements. It will support them. The bill does not make Mauritius a less attractive destination for legal immigrants. Instead, it is about stopping abusers and making illegal immigrants easier to remove by dealing firmly with those who harm our country. It allows us to continue to welcome those who will benefit. Mr. Speaker, sir, with the economic expansion of Mauritius and its pursuit to become a high-income economy, the Mauritian government is promoting openness to foreign investors, talents, know-how, and retirees. Foreign nationals may opt to invest, work, live, or retire in Mauritius through various avenues, namely the occupation permit, the residence permit, the young professional occupation permit, or the permanent residence permit. My address to the House will be threefold, Mr. Speaker, sir, namely, safeguard against marriage of convenience, consolidating the legal framework, and the importance of the bill for the economy. Mr. Speaker, sir, allow me to refer to a case of the Supreme Court, Singh v. versus Registrar of Civil Status 2017 SCG 135, which is a vivid example of a sham marriage. The Supreme Court stated the following, I quote, "I am satisfied that all the features highlighted above cumulatively tend to show that the application was dubious, and the applicant was trying to get married by any means to a Mauritian citizen in order to obtain the status of resident of Mauritius pursuant to Section 5(1)(c) of the Immigration Act. The decision of the respondent has not been shown, in the light of the evidence on record, to be illegal, unreasonable, or unfair. Our law does not particularly deal with sham marriage, but instead lays down the condition for a non-citizen to marry a citizen of Mauritius in the relevant provision of Part 4 of Civil Status Act, requiring strict compliance. With these conditions, since a non-citizen automatically acquires the status of resident of Mauritius by virtue of being a spouse of the citizen of Mauritius, the Civil Status Act accordingly provides for the publication of the proposed civil marriage by a non-citizen. Once published, any person who has any ground to object to the celebration may in turn lodge a notice of objection of the proposed marriage with the Registrar of Civil Status. It is at this stage that the authorities can intervene to prevent a marriage of convenience. The present legislation, as compared to the Immigration Act 1970, makes new provision to prevent situations where a non-citizen marries a citizen for the sole purpose of obtaining a residence permit to stay in Mauritius. A non-citizen spouse will not outright be eligible for a residence permit. The marriage between the non-citizen and the citizen will have to be a civil marriage, and the non-citizen spouse will, in lieu, obtain a temporary residence permit to stay in Mauritius for a period of 2 years. And after that period, the non-citizen spouse will be eligible to apply for a residence permit. The Immigration Department will be empowered to investigate into whether the marriage between a non-citizen and a citizen is a marriage of convenience, and if it is established to the satisfaction of the Immigration Department that the marriage is a marriage of convenience, the non-citizen will obtain a residence permit. Now, Mr. Speaker, sir, the bill makes provision for the stringent conditions to be adhered to where the marriage between a non-citizen and a citizen is celebrated outside Mauritius for the issuing of temporary residence permit. Furthermore, to enable other relevant authorities to conduct appropriate checks on non-citizens, the Civil Status Act is being amended to provide that a marriage between a non-citizen and a citizen will now be celebrated in Mauritius after 30 days of the publication of the marriage, instead of the current 10 days. In addition, the Mauritian Citizenship Act is being amended to provide that henceforth, when a non-citizen is married to a citizen, intends to be registered as a citizen of Mauritius, he will, 4 years after having been issued with a residence permit, be eligible to make an application to be registered as a citizen of Mauritius. These novel additions, Mr. Speaker, sir, will bolster our existing legal framework and ensure that convenience marriages are deterred by increasing the timeline in the different stages explained above. Mr. Speaker, sir, recently we witnessed lots of misinformation surrounding the lawful removal of Mr. Peter Juricek, a Slovakian national from the Mauritian territory by Slovakian authorities on Tuesday, 26 April 2022. At the time of his lawful removal from the Mauritian territory on Tuesday 26, Peter Juricek was the object of an Interpol Red Notice 1. He was a fugitive wanted for prosecution and was, in terms of the Red Notice, reported armed and dangerous. Mr. Speaker, sir, to deal with such situation, even better, other consequential amendments have been rendered necessary to the Deportation Act, the Economic Development Board Act, the Non-Citizen Employment Restriction Act, the Non-Citizen Property Restriction Act, and the Passport Act, so as to align these enactments and the new legislation. Allow me, Mr. Speaker, to briefly address comments made in press by an opposition MP in regard to consequential amendment being brought to Mauritius Citizenship Act, more precising to Section 11. I'm not a lawyer, Mr. Speaker, sir, but a simple reading of the existing Section 11 clearly shows that provision to deprive a person who has acquired citizenship by registration or naturalization under specific circumstances or part of the Act. The Member of Parliament, as usual, portrayed this amendment in dramatic fashion, just to mislead the population in believing that the amendment is being done with ulterior motives. And all this for political mileage. Mr. Speaker, sir, the new subsection being already contains its safeguards, inasmuch as a minister can only make use of it if he has reliable information and is satisfied that it is in the interest of the defense, public safety, or public order. Mr. Speaker, sir, to reassure the House and the population, let me make a parallel between the powers of the DPP. The DPP is empowered to discontinue proceedings at any point in time. There is no legal obligation on the DPP to give reason when discontinuing proceedings, and it is within his discretion whether to do so or not. Case Mohit V versus the Director of Public Prosecution 2007, SCG 97. However, the decision of the DPP is reviewable. Mr. Speaker, sir, the consequential amendment will facilitate the function of enforcement authorities in ensuring that people on our island are here legally, and if not, necessary action can be taken swiftly to deal with illegal immigrants or criminals. The economic impact of migration is often driven by ill-informed perceptions, which in turn can lead to public antagonism towards immigrants, commonly known as expats. These negative views risk jeopardizing efforts to adapt migration policies to the new economic and demographic challenges facing a small island state like Mauritius, where human capital plays a pivotal role in its existence. Like many nations, migration is a feature of social and economic life of Mauritius, but the profile of migrant population varies considerably. In part, this is because of the variety of sources of migration, including demographic, geographic, and economic. Migrant workers to Mauritius make important contribution to the labor market in both high and low skilled occupations. Over the past 10 years, immigrants represent 17% of the increase in the workforce of the country. The bulk of workforce is employed in textile, construction, fish processing, and retail sectors. In all these areas, immigrants are filling labor needs by taking up jobs regarded by domestic workers as unattractive or lacking career prospects. Migrants contribute more in taxes and social contribution than they receive in individual benefits. The impact is highest in the middle management and senior positions, where immigrants provide an estimated net benefit of about 1% of the GDP to the public purse. Employment is the single most important determinant of migrants' net fiscal contribution, particularly in countries with generous welfare state. Most immigrants, after all, do not come for social benefit, but to find work and to improve their life and those of their families. The effect of migration is twofold. First, migration has a demographic impact, not only by increasing the size of the population, but also by changing the age pyramid of Mauritius. Second, migrants arrive with skill and abilities, and so supplement the stock of human capital of the island. Mauritius has been rather astute in its employment law, one that has created a fine balance between boosting local business. Mr. Speaker, sir, this bill will enhance the immigration scene by providing the right legal framework and standard required to face the challenge laying ahead. Let me end by saying, Mr. Speaker, sir, that this government is continuing with its vision to upgrade the lifestyle and protection of its citizens. This bill is another step in the right direction and is evidence of the visionary approach of the Honorable Prime Minister to ensure that the development of Mauritius is being done in line with the international standards. Thank you, Mr. Speaker, sir.
D'abord, je déplore le fait qu'un tel projet de loi n'ait pas été circulé suffisamment avant la première lecture pour permettre aux Mauriciens, en général, de connaître les motivations du gouvernement. Un tel projet de loi suscite des interrogations et de la méfiance, d'autant plus que des pouvoirs accrus sont prévus, sont octroyés au Premier ministre. Quels sont les objectifs de ce projet de loi? L'objet de ce projet de loi serait de prévenir les mariages de convenance entre a citizen and a non-citizen. Et comment prévenir de tels mariages? Ce projet de loi prévoit d'octroyer un permis de résidence 2 ans après un mariage pour le citoyen étranger ou la citoyenne étrangère, et des pouvoirs sont délégués au chef de l'immigration. Ce projet de loi prévoit également d'octroyer des pouvoirs discrétionnaires au Premier ministre pour déchoir la nationalité mauricienne à une personne sans devoir en donner les raisons et sans aucun recours d'appel à cette personne. En effet, différentes dispositions de ce projet de loi prêtent à interrogation, à savoir le Consequential Amendment au paragraphe 39 qui propose d'amender le Mauritius Citizenship Act et se lit comme suit. The minister may, in his absolute discretion and without giving any reason, deprive any person of his citizenship of Mauritius if he has reliable information and is satisfied that it is in the interest of defense, public safety or public order. Cette section est contraire à l'article 15 de la Convention des Nations Unies sur les droits humains. No one shall be arbitrarily deprived of his nationality. La section est également contraire à l'article 7 de The African Charter on Human and People's Rights qui dit ceci. Every individual shall have the right to have his cause heard. This comprises the right to an appeal to competent national organs against acts of violating his fundamental rights. Effectivement, il n'y a aucun recours d'appel à cette décision arbitraire du Premier ministre. Cette section est rétrograde et dangereuse et doit être amendée. Autre point, cette loi, le projet de loi, fait provision de la possibilité de délégation de pouvoir conférée par le Premier ministre au directeur de l'immigration. The minister may, for the purposes of this act, delegate his powers to the supervising officer of the ministry and to the Director General of Immigration. Mais delegate voudrait dire qu'il n'est pas obligé de déléguer. It is not mandatory. Tous les pouvoirs seront conférés au Premier ministre. Il y aura sans nul doute des cas where discretionary powers may be used, and this may leave the doors open to tyranny or abusive use of power by the Prime Minister. Cette loi, encore une fois, je le dis, est dangereuse et arbitraire. Le MMM s'est longtemps battu pour que le conjoint étranger ayant épousé une Mauricienne puisse rester à Maurice. Cela pour rétablir les droits des Mauriciennes ayant épousé un étranger. On se souviendra qu'avant 1983, lorsqu'un Mauricien épouse une étrangère, cette dernière a automatiquement le statut de résidente permanente, alors que tel n'était pas le cas pour l'étranger qui épouse une Mauricienne. L'étranger ne devient pas automatiquement résident mauricien. Et cette situation était une discrimination flagrante vis-à-vis de la Mauricienne. Le MMM a donc combattu cette discrimination. Madame Zifra, alors figure de proue du MMM, et un groupe de femmes avaient ainsi constitué un front pour présenter au Comité des droits humains à Genève une plainte contre cette législation discriminatoire, à savoir the Immigration Act and the Deportation Act de 1970. Et elles ont gagné leur cause. C'était le début d'un changement et d'une nouvelle ère pour les femmes de ce pays. Et aujourd'hui, grâce au MMM, en vertu de l'article 5.1c de la loi sur l'immigration, un non-citoyen qui épouse une citoyenne de Maurice obtient automatiquement le statut de résident. Les présentes dispositions prévoient 2 ans pour obtenir un permis de résidence permanente après le mariage entre a citizen and a non-citizen. C'est une épée de Damoclès sur la tête de ceux et celles concernés. Attendre 2 ans pour un permis de résident, c'est l'incertitude. Cette situation risque de causer des ruptures de couple et un traumatisme aux enfants qui sont entre-temps issus de ce mariage. Ce nouveau projet de loi est un recul et une mauvaise évolution sur le plan législatif depuis 1983. La loi n'est pas statique, certes, mais elle se doit d'évoluer dans la bonne direction. L'État devrait être prudent quand il s'agit des familles et surtout quand il y a des enfants. Même si l'enfant et les parents sont réunis éventuellement, les effets de cette politique de séparation des familles sont durables. Le traumatisme de cette séparation aura un impact dévastateur. On se souviendra qu'en 2019, ce gouvernement est venu avec des amendements à la Immigration Amendment Act. Il y a eu des dénonciations de la manière de faire du gouvernement. Ce dernier refusait l'autorisation à M. Patrick Hoffman, citoyen belge, alors pilote d'Air Mauritius, de convoler en juste noces avec une Mauricienne. Dans son intervention sur le projet d'amendement de 2019, l'actuel ministre des Affaires étrangères, alors sur le banc de l'opposition, brandissait une lettre adressée à M. Hoffman par le PMO, laquelle lettre se lisait comme suit. As a non-citizen of Mauritius, you are trying to marry a citizen of Mauritius for the sole purpose to automatically acquire the status of resident. Et le député de commenter cette décision dans ce sens. Je cite. Est-ce que la raison a été l'absence à son poste de travail et sa décision de ne pas piloter un vol? Il avait produit un certificat médical à son employeur. Mais cette décision, que nous le voulions ou non, semble être une sanction et non une décision administrative. Je veux dire la décision de lui refuser la possibilité de se marier à Maurice. Fin de citation. Et le même député pose la question suivante au Premier ministre. Je cite. Est-ce que cette demande d'autorisation pour son mariage civil n'était pas un moyen déguisé d'empêcher M. Hoffman la possibilité d'acquérir la nationalité mauricienne? Fin de citation. La population se souvient également du cas de la Sri Lankaise, Madame Medagama, expulsée du pays alors qu'elle était enceinte de 8 mois et était sur le point d'accoucher, alors même qu'il y avait une injonction intérimaire du juge Annie. Cette expulsion et les critiques du Premier ministre d'alors provoquent la démission du juge. On ne sait pas ce qui est advenu de l'enfant, s'il a pu être réunifié avec son géniteur. Les dispositions de ce projet de loi vont à l'encontre des conventions internationales et régionales auxquelles nous sommes signataires. The UN Charter, the African Charter for Human Rights and the Rights of the People, the African Charter on the Rights of the Child, et va à l'encontre même de l'article 15.1 de notre Constitution qui se lit comme suit. No person shall be deprived of his freedom of movement, and for the purposes of this section, that freedom means the right to move freely throughout Mauritius, the right to reside in any part of Mauritius, the right to enter Mauritius, the right to leave Mauritius, and immunity from expulsion from Mauritius. L'esprit de ce projet de loi est également contraire au principe de best interest of the child de notre Children's Act. Et dans chacun de ces traités, l'arbitraire est la pierre de touche, le touchstone, de ce qui est considéré comme une ingérence illégale dans la famille. Il est un fait que les mariages impliquant des citoyens d'un pays et un non-citoyen sont de plus en plus courants aujourd'hui. Il est un fait également qu'il existe des faux mariages, des mariages blancs ou des mariages de convenance. Il existe déjà des provisions légales à de telles situations. Si le mariage n'a pas marché et il y a eu divorce, le citoyen étranger est déporté 6 mois après que le divorce ait été prononcé. La loi est claire. La section 6.2 de the Immigration Amendment Act stipule « Where a person has acquired his status of resident, he shall cease, subject to subsection 6 of this section, to be a resident 6 months after the termination of the marriage to the citizen. » Il y a en effet des cas où des individus contractent des mariages de convenance afin de faciliter l'entrée et le séjour d'étrangers à Maurice. Ce problème a toujours existé et continuera d'exister. Mais est-ce que l'on connaît les statistiques relatives? Est-ce qu'il y a eu une recrudescence de cas où les non-citoyens ont utilisé le mariage comme seul but d'obtenir un permis de résidence permanent? Sur quoi se base-t-on pour affirmer qu'il y a abus? Si abus il y a, il faut s'attaquer au problème en amont. Aujourd'hui, les informations sur une personne sont facilement accessibles. from a click of the mouse, on peut avoir toutes les informations que l'on recherche sur une personne. On peut le faire à travers un certificat de moralité issu de son pays d'origine, à travers Interpol, à travers les services de l'ambassade. La communication est tellement facile et les informations accessibles très rapidement. C'est pourquoi tout le monde a été surpris que dans le cas du Slovaque Ulricek, en réponse à une question parlementaire, le Premier ministre avait répondu que le gouvernement avait vérifié les informations sur cette personne notoire, mais rien n'a été trouvé. Il a fallu que les autorités slovaques elles-mêmes adressent une communication au gouvernement mauricien. Et c'est à partir de là que le gouvernement a su que cette personne était recherchée dans son pays. Alors qu'il suffisait de s'enquérir auprès des autorités slovaques. Si les autorités dites compétentes à Maurice avaient la volonté nécessaire, les informations requises auraient facilement pu être obtenues. L'article 36 du projet de loi définit un mariage de convenance. Marriage of convenience means a marriage between a non-citizen and a citizen, orchestrated for the sole purpose of the non-citizen obtaining a residence permit. Il incombera à un département de l'immigration de mener une enquête pour déterminer si le mariage entre un non-citizen et un citizen est un mariage de convenance. S'il est établi à la satisfaction du département de l'immigration que le mariage n'est pas un mariage de complaisance, le non-citoyen obtiendra un permis de séjour. Mais comment prouver si le mariage est un mariage de convenance? Difficile à prouver. Quel est le knowledge ou l'expertise du département de l'immigration pour déterminer si un mariage est un mariage de convenance? Est-ce qu'un directeur de l'immigration a les connaissances et l'expertise ou l'habilité nécessaires pour déterminer si un mariage est un mariage de convenance? Là aussi, on sent l'abus. Le directeur de l'immigration ne sera-t-il pas que le rubber stamp du Premier ministre? Pourquoi ne pas instituer un board, un panel d'experts, an independent and impartial body pour déterminer s'il y a mariage de convenance ou pas? Et le burden of proof devra être sur ce département, sur ce independent and impartial body. Dans l'affaire opposant Sadowska et le secrétaire d'État au département, la Cour suprême au Royaume-Uni en 2017 confirme que the burden of proof incombe au ministère de l'Intérieur de prouver l'existence d'un mariage de convenance. The standard of proof is the balance of probabilities. Ce projet de loi, pour terminer, ce projet de loi est un recul et n'aura pour résultat que des ruptures de mariage bona fide, des éclatements de famille et le chamboulement dans la vie des enfants. Le gouvernement se doit de revoir sa copie. Un tel projet aurait dû être circulé et permettre à la population d'en débattre. De toute façon, il n'y a aucune urgence, à moins qu'il y ait agenda caché. Trop de pouvoirs ne peuvent être octroyés à une seule personne. Power corrupts, and absolute power corrupts absolutely. J'en ai terminé. Merci.
Mr. Speaker, sir, I would like to start my intervention by commending the Honourable Prime Minister for coming up with a present bill, that is the immigration bill, which in my opinion is a very progressive piece of legislation. Mr. Speaker, sir, the Immigration Act of 1970 has been amended not less than 25 times in 52 years, and this is a clear indication of how dynamic migration in Mauritius is, in fact, as it is throughout the world. As the world is becoming a global village, migration is becoming a salient feature of a more interconnected world. While encouraging mobility, it is equally important to have the proper legal framework to ensure a holistic approach in securing safe and orderly practices, which will ultimately be beneficial for all in building resilience of individuals and communities. The immigration bill is a prerequisite for Mauritius in protecting our borders from the illegal movement of people and de facto from drugs and contraband, while at the same time promoting lawful entry and exit, which is essential to our country's security, economic prosperity, and territorial sovereignty. Mr. Speaker, sir, I am proud that this bill is being brought to the House by this government and by no other than the Prime Minister himself, Honorable Pravin Kumar Jagnnath, who, I will remind the House, is responsible for our Republic's national security and territorial integrity portfolios. Mr. Speaker, sir, the early growth and the historical development of the Mauritian population was in fact characterized by immigration. Mauritius does not have an indigenous population, and we are mainly descendants of Indian indentured laborers, Chinese traders, and African slaves. Even back then, there was the need to promote, to protect, and to plan for the safe growth of the population, and this already brings a preamble to the immigration bill being debated today in this House. Mr. Speaker, sir, the immigration bill has the primary objective of consolidating and strengthening the law with regard to the admission and the stay of non-citizens in Mauritius. The major benefit of this new bill would be the harmonization of other acts, such as the Deportation Act, the Economic Development Board Act, the Non-Citizens Employment Restriction Act, the Non-Citizens Property Restriction Act, and the Passports Act. Excuse me. The starting point when we talk about immigration is that in order for a non-citizen to enter Mauritius, he must have the correct authorization. In this respect, Mr. Speaker, sir, there are several types of permits in Mauritius, included but not limited to residence permit, permanent residence permit, occupation permit, family occupation permit, and so on and so forth. Mr. Speaker, sir, this bill identifies the key challenges of migration today. It brings stability and security to the country. Contractual migrant workers are playing a crucial role in our economy, more particularly in the manufacturing, construction, and tourism sectors. One should remember that it is not necessarily due to a shortage of skilled Mauritian workers, but because of the increase in the standard of living of our country, and this makes Mauritius a desirable and an attractive place to live and work. Therefore, Mr. Speaker, sir, increasingly, investors are bringing in foreign labor. Their expertise, skills, and efficiency at work are an essential value for the economy of our island in achieving our growth target. Mr. Speaker, sir, Mauritius, through this government, together with the Economic Development Board and other key stakeholders, has been developing planned and well-managed immigration programs with a number of friendly countries. One such program happens to be with the government of Quebec in Canada, which was initiated in 2019. Furthermore, several memoranda of understanding have been signed with countries such as the United Arab Emirates, the Republic of Seychelles, the Nepal, the State of Qatar, the People's Republic of China, and so on. Such agreements ensure that all the rights of migrant workers are respected right from the recruitment stage throughout their stay and until their return to their home country. Mr. Speaker, sir, Honorable Boulel stated in his intervention, he voiced out his qualms and concerns about marriages of convenience or sham marriages. This bill, as compared to the one of 1970, this bill caters for new provisions to precisely prevent such situations where a non-citizen marries a citizen for the sole purpose of obtaining a residence permit in Mauritius. I am certain that Honorable Boulel is very well aware that in the past we have had situations where non-citizens tried to curtail the law and abuse the system for the sole purpose of acquiring the status of a resident by contracting such fake marriages. In many cases, some of these non-citizens at the time of contracting a marriage in Mauritius were already married in their country of origin. Some contracted a marriage in Mauritius, then divorced within 1 or 2 years, and then moved into another marital relationship within 6 months, only to enable them to continue to stay in Mauritius. These people, Mr. Speaker, sir, got married with one intention only, and that is to secure a Mauritian citizenship. Even worse, Mr. Speaker, sir, quite often after obtaining this permit, the citizenship permit, these people ultimately file for a divorce and leave their Mauritian spouse to marry somebody from their own country of origin. And this bill is here to put a final end to such vicious circles. Mr. Speaker, sir, what is regrettable is that many young women fall victim of such crooked and ill-intentioned individuals. To avoid these unfortunate situations, it is therefore provided in the immigration bill that a non-citizen spouse will not outright be eligible for a residence permit. The marriage between a non-citizen and a citizen will have to be a civil marriage, and the non-citizen spouse will in lieu obtain a temporary residence permit to stay in Mauritius for a period of 2 years, and after that period, that non-citizen spouse will be eligible to apply for a residence permit. I do agree, Mr. Speaker, sir, with Honorable Boulel, who pointed out that sham marriages are quite different from broken marriages, and that is why, Mr. Speaker, sir, capacity building of stakeholders who are involved in the immigration process, capacity building of those stakeholders is of extreme importance. As a key authority, the Immigration Department will be further empowered to investigate into whether the marriage between a non-citizen and a Mauritian citizen is that of convenience, and if it is established to the satisfaction of the Immigration Department that the marriage is not one of convenience, then the non-citizens will obtain a residence permit. Allow me to emphasize, Mr. Speaker, sir, that this bill will enable relevant authorities to conduct appropriate checks on a non-citizen. The Civil Status Act is being amended to further provide that a marriage between a non-citizen and a citizen will now be celebrated in Mauritius after 30 days of the publication of the marriage instead of the current 10 days. It will also serve as a landmark in the region when it comes to immigration. Mr. Speaker, sir, with your permission, I will address a concern raised by Honorable Utim during his intervention. Our law, Mr. Speaker, sir, through the Protection from Domestic Violence Act, provides the legal basis for the protection of migrants who are victims of domestic violence. My ministry further provides children who are victims of trafficking or violence with immediate and long-term protective and support services through the Child Protection Services Unit of my ministry. Besides the child development units outstations across the island, there are dropping centres at Port Louis, and the residential care at Grande Rivière Northwest also provides protective and support services to children victims of trafficking. To allay the fears of both Honourable Utim and Honourable Navo-Marie, with regards to the best interest of the child, I wish to reassure the House that, of course, the best interest of the child is paramount according to the Section 4 of the Children's Act. But in the spirit of the laws, we shall not allow any person, irrespective of being a Mauritian, a citizen, a foreigner, to use our children as a shield to flout other existing legislations. The immigration bill is not being brought with the objective to discriminate, to expel, or to deprive people of their citizenship for frivolous reasons. It is here to regulate and ensure safe practices. This bill is being brought to ascertain that no one abuses the law to disrupt the socio-political landscape of our island, a landscape which we all, well, probably not us all, but at least the real patriots, we all cherish this socio-political landscape. We look and we work towards safeguarding this landscape. Honorable Navarre-Marie mentioned Mr. Hoffman in her intervention. I would very kindly ask the member to revisit the intentions of that individual. And they were not very good, and they were not good intentions at all. Mr. Speaker, sir, as a Minister of Gender Equality and Family Welfare, I note with satisfaction that under this bill, children of non-citizens who hold a valid work and residence permit will still have access to all levels of education under the same conditions as our Mauritian citizens. And for permanent residents and their spouses who hold an occupation or a work permit, they will have access to our labor market, thus promoting gender equality and equal treatment for all. Mr. Speaker, sir, the history of human migration has made Mauritius ethnically diverse, as we are all aware. On one hand, we have the reality of an aging population, and on the other hand, we have a wider spectrum of economic pillars. Therefore, Mr. Speaker, sir, we cannot exclude the contribution of migrants in the equation of our economic development. This bill is, in this context, simplifying the current legislation in a clear, in a precise and straightforward manner. Mr. Speaker, sir, concerns have been raised with regards to the powers of the Prime Minister to deprive a person of a Mauritian citizenship. This power, Mr. Speaker, sir, is not an absolute one. Such a power and discretion will be used only if the Prime Minister has reasonable grounds to believe that it is in the best interest of defense, of public safety, of public order, public morality, or public health to do so. Mr. Speaker, sir, in practice, this means that based on the information that will be provided to the Prime Minister by competent authorities, the Prime Minister, who I remind the House very humbly, is also the Minister of Defense, of Home Affairs and External Communications, is also the Minister for Rodrigues, Outer Island and Territorial Integrity. He will have the legal right to take a specific and a well-informed action at the right moment and always in the best interest of our Republic. This is the evidentiary threshold under the immigration bill, and therefore it would be wrong to allude that such a power is absolute and will be applied upon baseless grounds, Mr. Speaker, sir. To conclude, allow me to once again congratulate the Honourable Prime Minister for his foresightedness and for taking the bold initiative in bringing a piece of legislation that propels our country closer to international standards and fulfilling migrants' rights, while at the same time protecting our citizens, in particular our children, our young girls and women, by preventing malicious, ill-intentioned foreigners from taking advantage of our citizens and preventing abuse of our immigration framework. This government, our Prime Minister, has a primary mandate to protect our territory and our citizens. Long live the Republic of Mauritius. I thank you all for your attention.
Honourable members, I suspend the sitting for 30 minutes.
Thank you very much. Please be seated. Honorable Levin.
Yes, thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, with regard to this bill, if we have a look at paragraph 4, 5, and 6 of the explanatory memorandum, it has summarized the whole bill. That is, there has been no major changes being brought to conditions upon which residence permit, for example, or permit for a retired non-citizen, permanent residence permit, occupation permit, short-term occupation permit, and family occupation permit were granted under the current law. Same remains. The only change that is being brought is with regard to a resident where a non-citizen marries a citizen that is being reviewed. Mr. Deputy Speaker, I've been listening to most of the speakers with regard to this bill. Debates have been passionate, and indeed the subject matter is one that requires considerable and serious consideration both in this August Assembly, but most importantly amongst our people and the civil society at large. It is a fact, Mr. Deputy Speaker, that since independence and with the advent of the Immigration Act in 1970 and proclaimed in 1973, we have been adopting a rather rigid approach to immigration. Over the years, at least on 20 occasions, Mr. Deputy Speaker, the 1970 Act has been amended. Mr. Deputy Speaker, yes, there is a need for a comprehensive and up-to-date legal framework on the issue of immigration, but whether we should continue to adopt the same structure and mindset with regard to immigration, Mr. Deputy Speaker, is a debate in itself, not just in Mauritius, but worldwide. Mr. Deputy Speaker, we are day by day becoming more intolerant, selfish as a nation, if I may say so, Mr. Deputy Speaker. Selfish as a world, forgetting that the whole world was populated through migration. Mr. Deputy Speaker, since the beginning of time, people have been on the move. Migration is a fundamental and enduring part of our story as human beings. It has expanded our horizons and opportunities, and it has united us as a global family. We citizens of this country, all members of this House, Mr. Deputy Speaker, we are the descendants of immigrants. I will not go into the history of our country and how it was populated, but it suffices to say that Mauritius is a land of immigrants, Mr. Deputy Speaker. Our ancestors came as settlers, as colonizers, as slaves, as indentured laborers, as traders. And Mr. Deputy Speaker, it is my humble view that as a country, as a nation, it would have been in the spirit of fairness and the right to information that this bill, instead of being brought with a certificate of urgency before this August Assembly, same ought to have been disseminated further, first and foremost amongst the population. We should ask our people as to their views concerning this bill. We should have informed them as to the implications of this bill when it will be enacted. We should also provide our people with a roadmap as to our future immigration policy in the years to come. Yet, this is not the case with this bill, Mr. Deputy Speaker. The civil society has not been afforded with the opportunity to have working sessions, brainstorming on this bill. And this is something that is not in order on such an important piece of legislation. In his intervention, the Honorable Prime Minister has not provided us with much details as to statistics that will back up the necessity and relevance of all new provisions and clauses being introduced in this bill. We ought to know, for example, what is the situation with regard to illegal immigrants, prohibited immigrants, and also the number of marriages of convenience that we have witnessed so far to enable this House and the population to weigh the gravity, if any, of the situation with regard to marriage of convenience. Mr. Deputy Speaker, the Honourable Prime Minister has laid much emphasis on the fact that this bill will tackle this allegedly burning issue of marriage of convenience. Let me, Mr. Deputy Speaker, with your permission, go on this subject matter with regard to marriage of convenience, which I humbly feel has motivated the very basics of bringing this bill before this House. According to media reports and as per my information, Mr. Deputy Speaker, marriages of convenience, or what we call sham marriages, we've got some 15 to 20 cases involving African and European nationals that are being investigated. They involve foreign workers who have overstayed their work permit and fake students who have entered Mauritius on student visas and whose visas have now expired. But what is a marriage of convenience, and how do we define it for legal purposes, Mr. Deputy Speaker? True it is that our law, as it is, does not specifically deal with sham marriages, but instead lays down the conditions for a non-citizen to marry a citizen of Mauritius in the relevant provisions of the Civil Status Act. It is required, amongst others, Mr. Deputy Speaker, that strict compliance with these conditions, since a non-citizen automatically acquires the status of a resident of Mauritius by virtue of being a spouse of a Mauritian citizen, the Civil Status Act accordingly provides for the publication of a proposed civil marriage by a non-citizen. Once published, any person who has any ground to object to the celebration may in turn lodge a notice of objection of the proposed marriage with the Registrar of Civil Status. It is at this stage that the authorities can intervene to prevent a marriage of convenience. And if the genuineness of the proposed marriage is suspected, the Home Affairs Division of the Prime Minister's Office will lodge a notice of objection to the proposed marriage with the Registrar of Civil Status. Mr. Deputy Speaker, for the sake of clarity, I shall cite the case of Vikram Singh against the Registrar of Civil Status and others. It's a 2017 Supreme Court judgment case. As an example, Mr. Deputy Speaker, the applicant in this case, Mr. Vikram Singh, a non-citizen, had made a publication of his proposed marriage to a citizen of Mauritius in August 2016. The Home Affairs Division of the Prime Minister's Office suspected the genuineness of the marriage, had raised an objection to the effect that as a non-citizen, he was trying by all means to marry a Mauritian citizen for the sole purpose to acquire automatically the status of resident. The judging chambers upheld the decision of the registrar, taking into account the fairness of the hearing before the registrar. The judge ruled implicitly, Mr. Deputy Speaker, that the sole purpose of the marriage was one of convenience to enable the appellant to acquire the status of resident. And that meaning of sole purpose, Mr. Deputy Speaker, was canvassed in the UK Supreme Court case of Sadowska that was cited by Honourable Navarre-Marie earlier. In that case, Mr. Deputy Speaker, one Miss Sadowska, who had lived and worked in UK lawfully for several years, had intended to marry one Mr. Malik, a Pakistani citizen who was unlawfully staying in UK since his student visa had expired for some years. In compliance with the law, they published their intention of the proposed marriage. On the day they went to the registrar's office to get married, they were both questioned by the UK immigration authorities and arrested on the grounds that the marriage was one of convenience. In other words, in line with the EU directive 2004/38 EC, which was applicable to UK as a member state of Europe at that time, the marriage was contracted for the sole purpose of enjoying the right of free movement and residence in UK under the directive that someone would not have otherwise. That was the decision of the Immigration Tribunal. So in the UK, Mr. Deputy Speaker, we have a tribunal for cases with regards to immigration. And this issue of sole purpose should not literally be taken, but rather as meaning that the objective to obtain the right of entry and residence must be predominant purpose of the abusive conduct. So this was the rationale of this particular case. And the second point that they made was a marriage cannot be considered as a marriage of convenience simply because it brings an immigration advantage or indeed any other advantage. And again, as cited by Honorable Navarre-Marie, the onus of proof is on he who asserts must prove. And in this case, it was for the authorities to prove their case. Why I have taken these two cases, Mr. Deputy Speaker, because as it stands, Mr. Deputy Speaker, our legal system is robust enough to deal with marriage of convenience. We've got our Supreme Court, we can refer cases before the judge in chambers, and this new bill will in no case improve or tackle the situation as it stands. Those people who will try to engage in marriage of convenience, if they have this in mind, will just now go on a pause mode for 2 years. Each one of them in the couple living their life and will act after all the legal safeguards are met. So what is of paramount importance, Mr. Deputy Speaker, is our system of justice should be complemented with an efficient civil status office and a proactive immigration office. Those two institutions should be properly staffed and be provided with all the necessary facilities to operate. And as from a legal perspective, Mr. Deputy Speaker, it should not escape the vigilance of our authorities that a marriage of convenience is arguably a conspiracy, contrary to Section 109 of the Criminal Code Supplementary Act, as it entails an agreement between two persons to commit a wrongful act which is against public order. Whilst the non-citizen is likely to face a deportation, his or her local accomplice may well have to answer to a charge of conspiracy before our court. So, Mr. Deputy Speaker, our existing laws are available and efficient enough to deal with marriage of convenience. Mr. Deputy Speaker, another issue that is of concern to me in this bill is what most of our honorable friends from this side of the House has been saying. It concerns amendment being brought to Section 11 of the Mauritius Citizenship Act. Honorable members from this side of the House have lengthily canvassed this proposed amendment. Honorable Utim raised pertinent issues with regard to this amendment going against the principle of preventing a non-citizen from being stateless in breach of international conventions. The introduction of a new subsection 8, Mr. Deputy Speaker, that will give the Honorable Prime Minister absolute discretion and without giving any reason deprive any person of his citizenship of Mauritius if he has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. It goes against the spirit of accountability, Mr. Deputy Speaker. The more so that it stands that the existing provisions embedded in Section 11 of this Act already provide the Honourable Prime Minister with wide powers. What is lacking in this amendment, Mr. Deputy Speaker, is a check and balance mechanism. At a time when we are advocating for a more concerted approach on issues of national security, amongst others, I am of the view that honourable members of this august assembly should be empowered, and there should be a creation of a Home Affairs Committee, as is the case in the UK, for instance. This committee should be a cross-party committee of MPs responsible for scrutinizing the work of the Home Affairs Division of the PMO and its associated departments. It should, amongst others, examine government policy, spending, and the laws in areas including immigration, national security, and policing. And as a note of conclusion, Mr. Deputy Speaker, I will invite members of this August Assembly to take note of the recent revelation made in a documentary on the BBC with regard to Sir Mo Farah. Honourable members will recall that he is one of Britain's greatest ever athletes, having won as much as 4 Olympic gold medals for Great Britain. In recognition to his outstanding contribution to the field of sports and athletics, he was knighted and was bestowed upon with the prestigious title of Sir. He is now called Sir Mo Farah. Astonishingly, Mr. Deputy Speaker, he recently revealed that the truth is that his name isn't even Mo Farah. He revealed that he was born as Hussein Abdi Kahin in Somaliland, and that he is an illegal immigrant smuggled into the UK by traffickers when he was 9 years old. He was brought here under a false identity to work as a servant in the United Kingdom. And he says, and I quote, "Now at the age of 39, I must say the truth. The truth is I'm not what you think I am. And now, whatever the cost, I need to tell my real story." And he went on and relayed how he became an illegal immigrant and how he struggled to become where he is now. Fortunately, there, Mr. Deputy Speaker, the Home Office has adopted a fair approach and no actions whatsoever has been taken against him, and Sir Mo Farah stays on as a proud British citizen. How many such cases we have around the world, and even in Mauritius, Mr. Deputy Speaker, where people who have stayed in a country as illegal immigrants have later moved on to make the nation where he or she is living proud. Mr. Deputy Speaker, I have a liberal approach to immigration. I am of the view that as a land of immigrants, having no borders, having already existed legal framework to tackle all types of illegal practices related to immigration, instead of this bill adopting a restrictive approach, there ought to have a proper and widespread debate for the adoption of a national immigration policy for the next 30 years before coming up with an appropriate piece of legislation that will have a broader perspective to immigration. I must also remind this House, Mr. Deputy Speaker, that research on the net fiscal impact of immigration, I've listened to the Honourable Ramdani with regards to impact on our economy. So, research on the net fiscal impact of immigration shows that immigrants contribute significantly more in taxes than the benefits and services they receive in return. According to the World Bank, Mr. Deputy Speaker, increasing immigration by a margin equal to 3% of the workforce in developed countries would generate global economic gains of 356 billion USD. 366 billion USD. Some economists, Mr. Deputy Speaker, predict that if borders were completely open and workers were allowed to go where they pleased, of course, in an ideal world, we are not in an ideal world, it would produce gains as high as $39 trillion for the world economy over 25 years. Mr. Deputy Speaker, sir, I thus invite honourable members to have an open-mind approach to immigration, as we are all immigrants on this planet Earth. I thank you for your attention, Mr. Deputy Speaker.
Thank you, Mr. Deputy Speaker, sir. It is indeed an honor for me to take a call and to support this immigration bill. Mr. Speaker, sir, much has been said in all quarters: media, radio talk shows, newspapers, the political spectrums, among others. However, Mr. Deputy Speaker, sir, as I lend my voice to this piece of legislation presented by the Honourable Prime Minister, to this House, I call upon the good faith of my colleagues from the other side of the House. I have been listening to the former member, Honorable Lobin, who mentioned about liberal approach, open-minded approach, but on the same side of the House, there were some members who have made this debate around one single individual. That's the person, Peter Ulrich, who was actually deported. Allow me here to put few questions to those members of the opposition who took the floor and personalized the debates as they had their clients or clients of their friends involved in illicit activities. Let me refresh the memories of some friends on the other side. During an answer from the Prime Minister on the 10th of May 2022, where the Honorable Rizautim put a question with regard to that said person, the Honorable Prime Minister mentioned in his answer, I quote, "Mr. Speaker, sir, as I said, Mr. P.U. was wanted in Slovakia for establishing, masterminding, and supporting a criminal group, and also for the illicit manufacture, possession, and trafficking in narcotics and psychotropic substances, poisons, or precursors. I have also informed the House about the outcome of the case." So my question to members on the other side of the House who have tried to personalize the debate, trying to make the public at large feel that this bill has been brought specially to protect that person, to bringing this bill to work towards that person, I think they are getting it wrong. Because this person who was here in Mauritius wanted to have the Mauritian nationality. So I think this is an example why we should come forward with this immigration bill. Mr. Deputy Speaker, sir, I shall not be too long, but my speech would dwell upon the main object of the bill, which clearly dissipates any doubt, if so ever. The very main object of this bill is to consolidate and strengthen the law with regard to the admission and stay of non-citizens in Mauritius. Et non pas, si pas get figure, si pas pe compte figure, you go away. This is what has been said in this August Assembly. Well, it speaks a lot about what type of policymakers they shall be, but thank God they are on the other side of the House. Sinon, beaucoup figure pas pour passer. Anyways, coming to the essence of the bill, Mr. Speaker, sir, as I mentioned, we are talking about strengthening and consolidating an immigration act which exists since 1970s, where some of us were not even born. And this act, which dates far back, made provision for a limited category of non-citizens to be admitted and stay in Mauritius. And since then, as mentioned by my colleagues, the act has been amended several times to make place for retired citizens, investors, and non-citizens, as well as young professionals. Immigration on a worldwide basis has become an ever-increasing problem. Immigration is a cornerstone of any government's long-term goal in respect of economic transformation, our focus on families, young, old, and our national identity revolves around immigration. The new global environment has increased competition for skilled migrants, and there is a greater need to ensure that Mauritius is secure. With such facilities comes some serious issues which this bill comes to address. This bill does a number of things which I will highlight with some key issues in it. Mr. Speaker, sir, the very first issue is the marriage of convenience, which has become an alarming phenomenon not only in Mauritius but across the globe. People getting married for their own benefits and to get the papers and to be naturalized. As a responsible government, we had the urgency to address this issue. The legislation brought in this House clearly makes new provisions to avoid situations such as, 1, a non-citizen marries a citizen only for the sake of obtaining a resident permit to stay in the Paradise Island of Mauritius. Secondly, the marriage between the non-citizen and the citizen should be a civil marriage, and the non-citizen will have obtained a temporary residence permit to stay in Mauritius. Thirdly, following the 2 years, the non-citizen will be eligible for a residence permit. Furthermore, this bill also clearly provides support to non-citizens who, for any reason, medical, business, or any other reasonable purpose, had to travel abroad, but for 1 year has been under the same conjugal roof in Mauritius. Another element which is believed to be very important, which we need to lay emphasis in this new legislation, would empower the immigration officer. We have been discussing about the power given to the Prime Minister, but I couldn't hear members of the opposition mentioning about the power, about empowering the immigration officer, who will have the ability to investigate into the problem of marriage of convenience. Part 5 of the bill states clearly powers of the immigration officer. Section 21, non-citizen minors admitted to Mauritius. Section 22, examination by the immigration. Section 23, powers to refuse admission to Mauritius. Section 24, inspections. Section 25, powers of arrest, detention, and investigation. All lies upon the immigration officer. Mr. Speaker, sir, the aim of this bill is to modernize and future-proof our immigration legislation, which dates far back to the 1970s. As a responsible government, it is vital that we have legislation to allow us to protect the security of our citizens. This bill clearly brings a fair and balanced way of managing the immigration issues, which is a global issue. To conclude, Mr. Speaker, sir, I do not want to unduly delay the passage into law of this very important piece of legislation, but I add my congratulations to those who have been involved into drafting such an important bill, and especially to the Prime Minister for bringing such an important bill into the House. In view to safeguard the interests and well-being of our citizens, protecting them from being exploited, it is therefore important to consolidate and strengthen our immigration bill with such a robust bill. I therefore extend my full support to the Prime Minister and to this bill. Thank you very much for your attention.
Thank you very much. Short and precise. Honorable Fadumir, Dr. Mir.
Thank you, Mr. Deputy Speaker. My intervention this afternoon on the immigration bill will not be a long one, save and except that I wish to highlight certain contentious and somewhat alarming provisions which have come across when going through the bill. Mr. Deputy Speaker, sir, the bill has two major components. Firstly, the issue of marriage of convenience to obtain a residence permit, as well as the marriages between a citizen and a non-citizen, and its subsequent application for a resident permit. And secondly, the very consequential amendments to the Deportation Act, the EDB Act, the Mauritian Citizen Act, and the Passport Act. Mr. Deputy Speaker, sir, there is no doubt that our legislation needs to be tighter, and it comes to the so-called couple having resort to marriage of convenience, and surely such practices, which have been used by so many in different countries across the globe, have compelled immigration authorities across the globe to make new provisions to deter and prevent such scams where the sole aim, and I repeat, the sole aim, is to circumvent the rule of entry, obtain a permit of residence, and abuse the welfare state of the country. Mr. Deputy Speaker, sir, however, one has to be cautious, though, where there are many perfectly genuine marriages which may bring some immigration advantage to one or both parties involved, depending on where at the material time they wish to make their home of residence, and that obviously does not make it a scam marriages. Mr. Deputy Speaker, sir, people marry for a variety of reasons, and many genuine couples who might not otherwise marry do so in order to be able to stay with their loved ones in the country. It is therefore extremely important to define whether the sole purpose is to gain an immigration advantage, or whether the sole aim is to circumvent the rules of entry of residence. The issue is between what was the intention. Was it a sole purpose or a sole aim? And I hope that amendment to the law will clarify this issue as to the detection of genuine, what we would call a marriage of convenience. Mr. Deputy Speaker, sir, let me come straight to the other point. The immigration bill is not only brought to bring certain amendment or amendments to the existing legislation. The bill also seeks to revamp the whole landscape in terms of citizenship and the regulation of all permits, which are normally issued by the executive and the so-called independent authorities, and which may have dire consequences. Mr. Deputy Speaker, sir, one of the components of this bill, which has attracted a lot of discussion, either from this side of the House and members extra-parliamentary, from learned counsel and lawyers, is that Section 39(4) and subsection F, where the new subsection will be added to the Mauritian Citizenship Act, where I note the following: absolute discretion and without giving any reason, deprive any person of his citizenship of Mauritius if the Prime Minister or the Minister of Internal Affairs has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. Mr. Deputy Speaker, sir, as much as certain provisions are needed clearly, one must bear in mind that the new bill ought to be in line with the basic tenets of good governance. The decision of a person's citizenship should not rest within the sole discretion of the master of the day, and whoever be the master of the day, today, tomorrow, or in the years to come. Mr. Deputy Speaker, sir, if we now go to the Mauritian Citizenship Act of 1968, which the bill seeks to amend, and I have just read out, one would be aware and note the various safeguards which have been put in place prior to such a drastic decision being taken, the most so to be taken by one individual. Mr. Deputy Speaker, sir, for example, it used to be the case that before an order to deprive any person of its citizenship is taken, there is a statutory requirement that that person is afforded A, a right to an inquiry, B, a notice to be served on him, and C, if the inquiry and a report to a committee appointed by him for that purpose. Those were surely shooty measures to ensure that a fair and non-abusive decision were taken, but not solely based on personal views and opinion. Mr. Deputy Speaker, sir, what does that all mean now? It means simply that such a decision to deprive a person of its citizenship should not be left solely at the discretion of one person, in the present case, the Minister of Home Affairs. There used to be various safeguards, of which I have just mentioned, such that an order to deprive a person of his or her citizenship is not used in an abusive manner. Mr. Deputy Speaker, sir, I will just relate as an example a very telling case that happened in the United Kingdom only 5 years ago, when a young girl at the age of 15, named, well-known, Shamima Begum, decided to leave the United Kingdom. She is a citizen, born and bred, and decided to flee to Syria to join an infamous organization, ISIS, for reasons unknown to many, but decided that that were her dream. She wanted to live her life. Unfortunately, the whole dream fell apart, and she decided to come back to the United Kingdom in 2017 with an unborn child at the time. Mr. Deputy Speaker, sir, why I'm relating to that? At that material time, in 2019, the Secretary to Home Affairs, Mr. Sajid David, decided to strip her of her citizenship. And what happened next? She was allowed to pursue her request to come back to England to defend her case. And in July 2019, she even went to the Court of Appeal, where she was given the right to come back to UK and to fight her case of citizenship. However, the judiciary in this particular country also allowed the government of the United Kingdom to contest the ruling of the Court of Appeal. And it went to the Supreme Court, Mr. Deputy Speaker, sir. And in the Supreme Court, the Home Office appealed to the Supreme Court to reconsider the Court of Appeal judgment on the basis of significant national security risk. And the ruling was very simple. The President of the Supreme Court said that the government was entitled to prevent Ms. Begum to return to UK on the basis of national security threat and terrorism. What I'm trying to point out, that there is a clear demarcation between the executive and the judiciary, and whoever felt aggrieved at the time was given opportunities, there were safeguards, there was avenues to contest, and shooting measures to make sure she had a fair trial and a fair decision be implemented against her. Mr. Deputy Speaker, sir, not long ago here in Mauritius, we've seen the mess where one PU, Peter Yusef, was deported in a somewhat surprising manner, and which even necessitated rectification, clarification communique from the Office of the Prime Minister to reassure the population of the acts and doings of the government. But, Mr. Deputy Speaker, only last week, we've seen that the Director of Public Prosecution took the decision to proceed with the criminal contempt trial against the Passport and Immigration Office and the Civil Aviation due to judge orders not being respected. We are not condoning that such infamous individual, as said by Honorable who just spoke before me, Lachman Roy, that this guy was masterminding drug trafficking, was involved in heavy drug businesses and what's on. We were not the one who allowed him a red carpet through the Economic Development Board to come to this country. The check and balances were poor, and one has to accept that remedial approaches have to be taken in this manner. Mr. Deputy Speaker, sir, the fact that a communique had to be issued in that sense gave an indication of the manner in which the so-called deportation had been handled. The other case, Mr. Deputy Speaker, sir, of Patrick Hoffman, whereby he was deported and subsequently reported as a prohibited immigrant because it was believed he has caused great harm to the national aviation air Mauritius and industry, and also making subjective remarks. Let's not forget the Sri Lankan lady who was heavily pregnant of 6 months, and he was deported in circumstances we all know about. These were very subjective decisions. One, Mr. Deputy Speaker, sir, one must take lessons of the President of France, Mr. Hollande, who tried at some point in time to change the constitution to expel terrorists from mainland France. And he met with such opposition and upheaval in the country that he had to backfire and thereby stayed as it is. Mr. Speaker, sir, I will now come to the bill itself, particularly subsection 8.4c, where I note that the Minister of Home Affairs may issue a residence permit to a non-citizen where the non-citizen is, in the opinion of the minister, a fit and proper person to become resident. Mr. Deputy Speaker, sir, the granting of a residence permit to a non-citizen is something one must be very cautious. On what criteria would the minister determine that the non-citizen is a fit and proper person? Should that not remind the House of that infamous businessman, where one senior honorable gentleman sitting on the other side of the House, who has even acted as Prime Minister, said that he looked into the eyes of the businessman and was convinced that he was a genuine person. The subsequent trials of that gentleman is a central criminal investigation of court in Portugal only a couple of months ago says it all. I would say to my dear learned friend on the other side who just spoke before me, beaucoup figurent partis pour capables passer si nous étions au pouvoir. Truly, that businessman would have never had set foot here. Mr. Deputy Speaker, sir, amendments and new provisions in the bill must not and should not be the means to use one authoritative power against individual citizens who oppose and challenge the government in place, and acting upon one's discretion under the covert of national security risks or threat to strip them of their citizenship, but particularly if it happens to the offspring of foreign national. The constitutional rights of children born out of couple, binational, that is one parent being a foreign national, and the obtention of a national Mauritian nationality must be guaranteed. Mr. Deputy Speaker, sir, lastly, I would like to comment on Section 12 of the bill, which relates to the occupation and permits. I have not seen any provisions which give the power to the relevant authorities to carry out any checks or inquiries in relation to an applicant for an occupation permit. I again have to refer to the case of Mr. Urisek, where an occupation permit of 3 years was granted to him after allegedly verifications were carried out on the controversial list of Passport and Immigration Office, the Interpol database and World Check. And to find out there was only an international arrest against him in May 2020. And again, he's been a notorious drug trafficker, and only 3 years later, we realized this guy had to be deported. There is a way of doing it, because the way the Mauritian authorities have acted smacks clear amateurism. Mr. Deputy Speaker, sir, this sort of shortcoming and amateurism should not repeat itself, as it puts at risk population at large and forget the reputation of our country. It is therefore, in my humble view, that this new bill must contain provision to the effect and empower officers of the Director General of Immigration to be able to verify all the elements of applicants who wish to obtain and benefit an occupation permit. The alleged occupation with the intent to undertake must be thoroughly verified, and the bill must be amended to include those powers. Finally, Mr. Deputy Speaker, sir, I note with satisfaction that the period of notice for marriages between non-citizens and citizens has been extended from 10 days to 30 days, which I hope is made in the view to allow the more thorough checks and inquiries to be carried out on non-citizens to ensure that the marriage is not simply a routine to obtain citizenship in Mauritius. I further note that a non-citizen does not de facto will acquire citizenship the moment he or she is married to a Mauritian citizen. This is also a step forward to prevent the mariage blanc, like it is referred in French. To conclude, Mr. Deputy Speaker, sir, I can only hope that my suggestion and positive criticism will be taken on board by the executive, as this is above political partisan. Thank you.
Thank you very much, Honorable Daniel.
Thank you, Mr. Deputy Speaker, sir. Listening to the speaker speaking before me, I don't think he has read why we are making this amendment. If we had in the past this legislation, would not have been the case for PU. You understand that when PU entered Mauritius, you said that there was not regular check was done, but you should know also that the Economic Development Board used the World Check, and all relevant checks that has been done, he was not condemned at that time. This is important to know, because when the government of Mauritius was made aware of the international arrest, the Attorney General Office and the Prime Minister's Office acted promptly. And this is why this gentleman is no longer in this country. And when we are bringing amendment to this act today, when we are talking about this, many things has been said about this citizenship act by Honorable Utim, yourself, the member that speak before me. But why are we doing it? It's important to understand that. It is, if tomorrow we have a terrorist in this country, so we know that in the past, there is the law. You can also go toward the Supreme Court, because it's by our Constitution. But now, if the Prime Minister gets an information on a terrorist, he will write to him, tell him, I'm going, to prohibit you from being in this country because I suspect you to be a terrorist, and he will go in the court. By that time, Mauritius will be explosé. We need to act properly. But the law is still here. Even if he's repealed from his citizenship, he can still use the Supreme Court. This is not that the opposition has been telling,
And this reminds me of how there was the same, in 2019, reading in Hansard. There was the same, when the opposition was saying the same tactics and using the same thing that we are giving too much powers to the Prime Minister. Et c'est un point qui a suscité beaucoup de débats, c'est la discrétion conférée au Premier ministre. And here I would like to quote Honorable Ivan Kolandavelu from the Hansard in 2019, during the same Immigration Act. Je suis tenté de dire, si un Premier ministre, on ne vous donne pas une discrétion, mais à qui on va donner de discrétion? Le Premier ministre reçoit une information et il lit cette information et se dit que cette personne raisonnablement sera indésirable. Cela a mené à des excès de commentaires tels qu'à partir maintenant, on devrait adresser à l'honorable Pravin Jagnnath comme Sa Majesté, puisque à partir maintenant, il faudra avoir sa permission avant de se marier à un ou une étrangère. Où est-ce qu'on va chercher dans ce texte de loi? Il faut savoir un esprit véritablement tordu pour trouver cela. I quote, Mr. Deputy Speaker, sir. We have a Prime Minister which has been democratically elected by the people of the Republic of Mauritius. And here we on the side of this House, we have full confidence in his judgment, and we know information won't come from Honorable Dunn, who is going to give the Prime Minister information about a foreigner or someone who is coming here. It's about intelligence. We're not talking about what are we talking. We're talking about intelligence, Mr. Deputy Speaker, sir. And we have intelligence between our partner countries. This is how we are going to proceed, Mr. Deputy Speaker, sir. And, Monsieur le Président, Maurice est classé parmi les 21 pays considérés comme fully democracy par l'économiste et intelligence unie de le rapport 2021, parmi les 21 pays. Nous sommes le seul pays en Afrique parmi les 21 qui sont dans ce rapport comme fully démocratie. Parce que vous allez voir qu'est-ce qu'ils ont quand l'opposition fait leur marche, ils sont autorisés, mais ils vont dire que nous sommes dans la dictature. C'est tout le temps comme ça. Depuis que nous sommes là, on a attendu ça. Le Premier ministre est un dictateur, le gouvernement est dictateur, et nous empêchons, et nous sommes en train de donner trop de pouvoir au Premier ministre maintenant dans ce texte de loi pour qu'il puisse revoir les citizenship. Mais moi, je vais aussi, parce que l'honorable Lobin a parlé, et il a demandé des statistiques. Moi aussi, je voudrais des statistiques du Premier ministre depuis le Immigration Act de 2019. Combien de prohibited immigrants there has been? On a parlé, on a dit que il y avait l'honorable Ting qui était inquiet par rapport à des côtés de la Chambre qui sont mariés à des étrangers. Mais si on a dit aussi qu'il pourra demain, le Premier ministre, servir de cette loi pour faire vengeance politique. Mais combien de gens de l'honorable banque qui sont mariés avec des étrangers ici ont été prohibited immigrants? Moi, je voudrais savoir ça du Premier ministre. Mais non, nous sommes en train de les accueillir parce que, comme nous avons dit et comme nous le savons nous ici, oui, we are in a land of immigrants. I agree. Parce que Maurice a été créé, nous avons des gens qui sont venus de toutes les parts du monde. Et aujourd'hui, on vient nous dire que le Premier ministre va servir de ce pouvoir pour faire du tort à des épouses des membres de l'opposition. Je ne sais pas où on va chercher ces arguments-là. Parce qu'ici, qu'est-ce qu'on fait? Nous sommes en train de les encourager d'investir et de faire du business aussi. Si vous allez voir, nous n'avons pas bloqué personne, Monsieur le Président de la Chambre. Venant coming to the Act, like everyone has said, in 1970, the Act was complex, but simplified legislation was required. And this enactment of this new bill is warmly welcome since the present Immigration Act dates back to 1970 and has been amended 20 times. The result is that we have a legislation which was complex and difficult to understand. The new piece of legislation is easy to read, making it a good marketing tool for investors and is in line with the spirit of openness. Comme on le dit, il fallait revoir la politique nationale de l'immigration. Parce que dans les années 2000, Maurice s'ouvre au monde et il y a la migration circulaire. Les Mauriciens vont vivre ailleurs et les étrangers sont en train d'inviter venir travailler à l'île Maurice. Et nous avons vu aussi que c'est une question de pouvoir balancer. D'abord, de la nécessité de protéger la liberté de mouvement, les droits fondamentaux de la famille, le droit de la famille d'être toujours réunis, mais aussi le droit de l'État de se protéger contre des personnes que nous, les prohibited immigrants, qualifiés dans ce texte de loi par rapport à les activités qu'ils sont en train de faire. Parce que nous devons protéger nos citoyens et aussi notre petite île Maurice, petit État insulaire, Small Island Development State. Il faut le faire, Monsieur le Président. Mais aussi, quand on parle de prohibit the marriage of convenience, the main aim of the new piece of legislation is to prohibit marriage of convenience, les mariages orchestrés, for the sole purpose of obtaining residence permit. To this end, the law is being strengthened so that a non-citizen is not outright be eligible for a residence permit. The concept of a temporary residence permit is being introduced. Thus, a non-citizen spouse who is civilly married will obtain a permit allowing the spouse to stay for a period of 2 years. It is only after this period of 2 years that the spouse will be entitled to apply for a residence permit, which is good. But when listening to Honorable Lobin also, when we look at the European Convention on Human Rights and also which reflects in the International Government on Human Rights, so when you see the number of applications that has been made religiously to the European Court of Human Rights under Article 8, many cases for spouse visa are refused on the ground of national security and the ground of public morality. And Mr. Deputy Speaker, sir, the law had to be amended in England and Wales so as to ensure that the number of immigration regulations were amended so as to secure their border. And that's why even structure of the Foreign Office and the Home Office that had to implement introduced another special branch in UK Border Agency. Now it is not the Home Office that deals with it, it is a UK Border Agency. Mais, Monsieur le Président, il y a aussi, on a pris l'exemple de l'Angleterre, mais en Angleterre aussi, on peut repeal le citizenship. En France aussi, on le fait. Mais pourquoi pas l'île Maurice? Si nous avons des oiseaux, des immigrants qui ont fait des actes qui ne sont pas, comme on dit, des terroristes, des gens qui sont illicites, des drug dealers, drug traffickers, on doit protéger notre pays. C'est pour cela que cet amendement, nous l'apportons au Parlement aujourd'hui. Mais pour venir aussi, je voulais aussi répondre à l'honorable Boulel. L'honorable Boulel avait dit, Monsieur le Président, dans son intervention, Mr. Deputy Speaker, let me quote l'honorable Boulel, Mr. Deputy Speaker, sir, the MSM regime is very cruel, and I can refer to the battalion of cases to show it's impervious or insensitive to human rights issues. The case of a Belgian pilot married to a Mauritian citizen is a classic case of what it means to be a victim of unfettered powers conferred upon the minister or prime minister. And on 16 April 2019, amendment to the Immigration Act of 1970 was passed to make the pilot. I think many use this example. Mr. P. Hoffman, a prohibited immigrant in virtue of Section 8(1)(m. There was also the case of the Sri Lankan lady who was more than 7 months pregnant. Ring a bell, she was jumped on a flight to Sri Lanka and decision was taken despite a favorable ruling given by the Supreme Court to stay action, that is the MSM culture, devoid of human feelings and indifferent to the rule of law. The MSM bend the rule to serve its purpose. Money talks indeed. Unquote. Monsieur le vice-président, si nous avons quelqu'un qui nous avons donné un residence permit, il entraîne de faire des désordres et un Mauritius et nous coûte à l'État et à la compagnie nationale, qui aujourd'hui nous savons dans quel état est le paillant queue. Mais je vois, pourquoi pas le Premier ministre n'agit pas? Il doit agir, parce qu'on doit protéger notre pays et aussi nos compagnies nationales. Mais venant au Sri Lanka, au case de Sri Lanka, je suis allé voir par rapport du cas que l'honorable Boulel avait mentionné. Il avait mentionné le cas de M. Djogui. Hein? Il avait mentionné ça. Laissez-moi, Monsieur le Président. Il a visité Djogui et c'est le cas de Djogui et Meda Gama. Je ne suis pas un homme de loi ou comme l'honorable Tim, l'honorable Bin ou même l'autre, mais je vais citer ce que j'ai lu dans le jugement. Djogui vient précisément établir ce que tout le monde vient dire. Je ne vais pas relire tout ce qu'il y a dans le... Monsieur Djogui avait entré une application. Sa femme était une Sri Lankaise, enceinte de 8 mois, menacée de déportation. Ils vont devant le juge et demandent de suspendre l'ordre. Le juge, contrairement à ce que l'honorable m'a dit, n'avait jamais donné une injonction. Il avait refusé l'injonction. Le jugement est devant moi. Il avait demandé à l'État de venir s'expliquer. L'État, se prévalant de cette petite faille, avait pris Mme Djogui, il l'avait mise sur le premier avion et l'avait renvoyée quelque part. Le juge Annie, se prévalant de ce que le Home Secretary avait fait, a subi dans une affaire quelque temps auparavant, dans l'affaire de M contre le Home Secretary, avait à cette époque été trouvé coupable d'outrage et se prévalant de ça, se dit, I quote Mr. Deputy Speaker, je demande au DPP d'examiner si dans le cas du Premier ministre d'alors, Feu Shanirou Jagnat, nommé dans le jugement, le gouvernement, le commissaire de police, et n'avait pas été coupable d'outrage à la cour. Unquote. Mais ce que l'honorable Boulel ne nous dit pas, ce que personne ne dit, ce qui paraît dans le jugement aussi, c'est que M. Djogui, celui qui avait fait l'affidavit et avait présenté la demande en cours, n'était pas M. Djogui, le mari de Mme Medagama. C'était un faux. C'était l'amant de cette dame-là. Et Feu Sir Gaëtan Duval, qui avait été son avocat, n'était pas à Maurice quand tout cela est arrivé. Quand il débarque, Maurice, il s'apprend tout cela, il va voir le juge Annie, qui lui se retire de cette affaire-là et ne veut pas avoir à défausser. Il se retire de l'affaire et le juge nomme Awaldo d'office ainsi que d'autres avoués pour paraître d'office pour ce M. Djogui. La police capte M. Djogui, bien sûr, et va chercher le véritable M. Djogui. Le véritable M. Djogui dit, oui, j'avais épousé cette femme parce que j'étais fou amoureux d'elle et qu'elle faisait semblant d'être amoureuse de moi uniquement pour avoir la nationalité, mais au fait, elle avait un autre amant qu'elle vivait et qu'elle entendait un enfant. C'est la vérité, et quand véritable Djogui vient devant le juge et dit, monsieur le juge, je suis le premier à demander la déportation de cette dame, ma femme. Et c'est comme ça, le juge Annie ne démissionne pas parce que la dame a été déportée. Il démissionne parce que le DPP et lui tombe en désaccord avec le chef juge et le DPP d'alors. Je vous dis ça, et c'est pour cela qu'il avait pris sa retraite, non pas pour ces choses burlesques que nous avons entendues, mais il faut dire la vérité, l'honorable Boulel. Comment c'était dans le jugement, pas en partie. On doit tout dire. Et Monsieur le Président, je voulais aussi venir par rapport à, comme on dit, in this bill, the immigration officers are being empowered to investigate whether marriage being a non-citizen and a citizen is a marriage of convenience. The Civil Status Act is also being amended to provide that a marriage between a non-citizen and a citizen will now be celebrated in Mauritius after 30 days of the publication of the marriage, instead of 10 days. This is being done to give to the relevant authorities adequate time so that they may conduct appropriate checks. These measures will ensure that there are no marriage of convenience and that Mauritius grants residency only to deserving people who meet criteria to set out in the law. It is important for us to preserve the good repute of Mauritius. With regards to young professionals, we have talked a lot, and it is recognized in the businesses lack the required labor force to enable them to prosper and grow. We have a skill mismatch. This is true, Mr. Deputy Speaker, sir. For this reason, we welcome the fact that the field of activity under which young professional may apply for a young professional permit, which will enable them to work and reside in Mauritius, is being increased to include fields such as architecture and design, communication and media, creative industry, engineering, logistics and supply chain, travel and tourism. This is an important measure to support our businesses. The importance of good repute of Mauritius, I have stated it earlier, Mr. Speaker, sir. Mr. Deputy Speaker, sir, that we are reviewing the sentences to a fine not exceeding 1 million rupees and a term not exceeding 12 months of imprisonment, and for 5 years showing the commitment and determination to send a strong signal that breaches of Immigration Act will not be treated with leniency. We talk about fractional ownership also. The Immigration Act is also being amended so that a residential property acquired by more than one non-citizen will be eligible to apply for status of residency, provided that the investment by each non-citizen exceed 375,000 USD. A non-citizen property restriction act, by the way of consequential amendment, the non-citizen property restriction act is being amended to allow non-citizens who are resident to purchase property outside the existing scheme, as long as the purchase price is not than 350,000 US dollars. Thus, holders of temporary residence permit, permanent residence, occupation, short-term occupation, family occupation may be allowed to acquire property other than residential property situated on a pas-géométrique, BLN, or service land exceeding 1.5 ARPA, standalone residential property constructed in land exceeding 1.5 ARPA. And to conclude, Mr. Deputy Speaker, sir, I would like to commend the Prime Minister and all the team that has worked on this bill, so that we are here to protect our citizens and protect our country in the best way. And we, on this side of the House, we are in for this bill. Thank you, Mr. Deputy Speaker, sir.
Thank you very much, Honorable Buddha, please.
Thank you, Mr. Deputy Speaker. Mr. Deputy Speaker, sir, we are a land of immigrants. This has been said. We are no longer a land of immigration. I'm thinking of Australia or Canada. But we are a land of migrant workers, where we have tens of thousands of workers with this temporary stay in Mauritius. So we are a land where we allow some immigration according to our according to our national interest, for purposes like investment, retiree residents, self-employed, professionals, young professionals. These categories are clearly set, and we have been opening our economy and our country since 2005, where the scheme of occupation permit was launched. In fact, it combined, for the first time, the resident permit and the work permit in one document. And it introduced the concept of silent agreement, which is still being valid in this law. Mr. Deputy Speaker, sir, in the 1990s, I was the chairperson of the Work Permit Committee when massive import of labor was introduced in the wake of a dynamic and very vibrant textile sector. Before that, a work permit would take more than 6 months. But the idea was to make things faster so that the vibrant textile industry could have the workers which it needed. And today, the occupation permit can be obtained with the silent agreement within 5 days. It is clear, Mr. Deputy Speaker, that the Prime Minister and the Prime Minister's office want to cure certain loopholes and abuses in the legislation of today. But I am convinced that the amendments are too autocratic, contrary to the UN conventions, contrary to UN charters, contrary to the African charters. My colleagues on this side of the House have mentioned these issues. The amendments, the new bill, raise constitutional issues such as discrimination and the right to a legal remedy against the absolute discretion which the bill gives to the Prime Minister. The first thing I would like to say, Mr. Deputy Speaker, is that in section when it relates to deprivation of status of resident in clause 18, we are given a list where the minister, that is the Prime Minister, is satisfied. When he is satisfied, he can deprive somebody of his status of resident. And in subsection 2, we have this famous sentence which has been criticized all the way, not only in this assembly, but outside as well by eminent lawyers and the public in general, which says, notwithstanding subsection 1, where you have the categories where the Prime Minister can deprive the resident, where the minister is satisfied that it is in the public interest to do so, he may, in his absolute discretion, deprive a non-citizen of his status of residence. I am proposing that we remove the word absolute. And we can keep the word discretion, but we all know that discretion by a Prime Minister or the Prime Minister's office or any institution has to be used judiciously and not as a punishment. An unfettered discretion cannot be allowed in a democratic society, Mr. Speaker, sir, Mr. Deputy Speaker. I'm also astounded by the fact that the word minister, that is the Prime Minister, is mentioned 59 times in this bill. And in all cases, you have the criteria. We have the criteria where the law can be applied, and then we have the situation where, notwithstanding those criteria, the Prime Minister can use his discretion. I'm going to take a few examples. But before that, I would like to go back to 1977, where the Human Committee of Human Rights raised the issue of Mauritius, where Mauritian women said that there was a discrimination because their spouse couldn't stay in Mauritius and had to apply for a residence permit. There was a convention then, Mr. Deputy Speaker, which said that the wife has the legal duty and the moral obligation to be with the husband. So if a Mauritian lady was getting married to a non-citizen, she had to accompany the non-citizen to his place to his to his place of residence. So the Mauritian wife couldn't stay in Mauritius and had to accompany the husband, and the husband couldn't stay in Mauritius because he had to go to his country of abode. And this is what the committee said. The committee found out, Mr. Deputy Speaker, the Committee of the United Nations, that any discrimination on the ground of sex within Mauritian legislation without sufficient justification was tantamount to a violation of Articles 2 and 3 in conjunction with Article 17, as well as direct violations of Article 25 and 23 of the UN Charter. So the committee recommended that Mauritius adjust the provisions of the Immigration Amendment Act 1977 and the Deportation Act, and had to implement its obligations to prevent sex discrimination in its laws and regulations, Mr. Deputy Speaker. Sir. Now let me come to the legislation, Mr. Deputy Speaker. We have the introduction of the temporary residence permit, where a spouse of a Mauritian citizen is given a permit for 2 years after getting married. Honorable Navar raised this issue of how this can affect the future of a marriage or the future of a family, how a spouse of a Mauritian citizen doesn't know whether he or she will be given the opportunity to stay in the country after 2 years and being given the status of a temporary resident when they have to have a family, take loans, build up their future. And if somebody, a non-citizen, gets married to a citizen of Mauritius and they decide to live in Mauritius, what does that mean? It means that that person has decided to make Mauritius the land where he or she wants to have a future. So I'm totally against this temporary residence permit of 2 years, and then have to wait another 2 years to be able to apply for a resident permit, which is going to be later, which can become a permanent residence permit. Now, let me go to clause 5, where we can restrict on admission or remaining in Mauritius. Notwithstanding this act, no one shall be admitted to Mauritius whilst being in Mauritius, remain where the person suffers from an infectious, a contagious, or a communicable disease. A person who has been convicted, this we can prove this. C, a prostitute or a person who lives on the earnings of a prostitute, or a person who is reasonably suspected to come to Mauritius for an immoral purpose. D, a habitual beggar or a vagrant. E, a person who is likely to become a charge on public funds. F, a person who is a chronic alcoholic. G, a person who is a drug addict or is reasonably suspected of engaging in drug trafficking. Then you have the other classes where you have the issue of subversive activity and terrorism. Now, according to the law, these criteria will apply to somebody who wants to enter the country at the airport, or somebody who is in the country and wants to have a permit. How in practice this is going to be implemented, Mr. Deputy Speaker? Now, I continue. Then we come to the section K, where a person who, from information or advice which in the opinion of the minister, that is the Prime Minister, is reliable information or advice and is likely to be undesirable habitant. How do we define reliable information, advice, and we decide on the possibility of that person to stay in Mauritius or to be evicted from Mauritius? I have been in the Prime Minister's office, Mr. Deputy Speaker, and I can tell you that you have many anonymous letters from aggrieved citizens or non-citizens writing all sorts of stories just because they have a personal problem with a migrant, a citizen or a non-citizen. When will the Prime Minister have time to check whether the information or the advice and the information has to be reliable, which proves that the person is undesirable? But these words in law, what do they mean? How do we apply them? And when we say then that we can have absolute discretion, Mr. Speaker, sir, then you have a person or a class of person where again we have this, in the opinion of the Prime Minister, is reliable information. Where is the due diligence done? Or advice again is likely to be prejudicial to the interests of defense, public safety, public order, public morality or public health. This is a blanket. And when you have a blanket together with absolute discretion, you know that you can do whatever you like, Mr. Deputy Speaker, sir. And again, in the end, section N, any other person who from information again, reliable source, advice, has been conducting himself or in a manner prejudicial to the peace, defense, public safety, public order, public morality, public health, security, or good governance of Mauritius. But this is too broad an umbrella. And I think that that's where I said we have to remove this issue of absolute discretion. Then again, you have all the criteria, they cannot enter, they cannot remain. But notwithstanding subsection 1, that is all the criteria, the minister may, on such conditions as he may impose, authorize in writing under his hand and under the hand of a person designated by him, a non-citizen to be admitted in Mauritius or to remain in Mauritius. At the end of the day, c'est la discrétion du roi to stay or not to stay, to enter or not to enter. That's why I'm saying, Mr. Deputy Speaker, sir, that this is too much of powers. Now you have the eligibility for a residence permit, and again, here we have the integrated resort scheme, real estate scheme, investment home scheme, property development scheme, and again, we come to the sum of $375,000 US. But again here, later I will say, the due diligence exercise in many cases have been flawed. And we know, I'm not going to talk about the individual cases which have been mentioned on both sides of the House. But the due diligence exercise by the EDB in many cases has been flawed, source of funds. So what I'm saying, in fact, is that strict laws and absolute discretion is not the solution. I will come back now to this residence permit, where you are given the different categories, and again, it relates to $375,000. And then, in the end, again, all these criteria do not matter. If he's a student in Mauritius, he's in actual attendance and in college. But the Prime Minister can allow him to have a residence permit if he is such person who belongs to such class of persons as the Prime Minister thinks fit and proper. How do we define the fit and proper? Who is fit and who is proper to stay and not to stay, Mr. Speaker, sir? Again, we come to this issue of discretion Mr. Deputy Speaker, sir. And we come again, where an application is made under subsection 2, the non-citizen means the requirements of this act. The Director General of Immigration may, with the approval of the Prime Minister, issue the non-citizen with a residence permit. Or, if he does not meet the requirements of the Act, then the Director General of Immigration shall reject the application. However, notwithstanding this section, the Prime Minister may issue a residence permit to a non-citizen, where the non-citizen is, in the opinion of the Minister, a fit and proper person to become a resident. So we have a set of criteria, but at the end of the day, we do not apply the set of criteria because then the Prime Minister has the absolute discretion to say yes or to say no. Mr. Deputy Speaker, let me now come to the permanent residence scheme, where you have the holder of a residence permit as a retiree or an occupation permit. He can apply for the permanent residence scheme. And the permanent residence scheme is for a period of 20 years. I have only 2 minutes? Oh, I'm sorry, Mr. Deputy Speaker. Well, then I will, before concluding, I have to conclude, is the issue of occupation permit. This silent agreement system, where the Director of the Immigration shall, on receipt of an application, immediately issue an acknowledgement of receipt, and within 5 working days, if nothing is done with the silent agreement, that person will be given an occupation permit. And we know the flows. We know what has happened in the past. So what I'm proposing, Mr. Speaker, sir, Mr. Deputy Speaker, is that the issue of strict laws, absolute discretion to the Prime Minister is not the solution. We have to reinforce our institutions, but that is another big problem. For example, the EDB, for example, the FIU. We should have the due diligence. We should have the image of a country, Mr. Deputy Speaker, sir. We cannot have the image of a country where the Prime Minister decides who is going to come in and who is going to stay and who is going to be evicted. And the Ministry of Labour has to have a proper due diligence exercise before the tens of thousands of migrant workers are coming to Mauritius. We know how the job contractors work. We know what is happening at the ministry. How did they get the permit? So, Mr. Deputy Speaker, sir, I'm going to end on by saying this. We have to remove the word absolute discretion. The bill tarnishes the image of Mauritius as a land of promise, be it for the investor, be it for the student, being for the young professional. We want to be a Mauritius which is a welcoming hub. This is our future, and we should have the mechanism to be able to see to it who comes in, who stays, who can make Mauritius a land of promise and where he can set up a new life, start a new life. But it is not with strict laws and absolute discretion to the Prime Minister that we can do this. Thank you, Mr. Deputy Speaker, sir.
Thank you very much, Mr. Speaker. Shall resume the chair.
Please be seated. Honorable Tilak.
Thank you, Mr. Speaker, sir. The debates around the immigration bill, surtout les discours venant des bancs de l'opposition, appear to be a bis repetita of speeches made by the opposition in 2019 when the immigration amendment bill was introduced. Of course, save for Honorable Buddha, who was at that time sitting on this side and who supported the philosophy of the immigration amendment bill, and surprisingly today is strongly opposed. Inale too.
You continue.
I think he was aware that I was going to refer to his speech. Mr. Speaker, sir, a lot has been said, and though some members have had reservations as to why the government is coming forward with the new immigration bill, Mr. Speaker, sir, it is clear, as lengthily debated already, that the 1970 Act, as amended, need to be revamped, and there is a need to bring in new provisions to adopt with the new immigration realities. So many countries are tightening their immigration policies. Countries like France, England, Australia, New Zealand, which previously had lenient immigration policies, are today tightening their laws. Mr. Speaker, our country has historically been a land of settlement, and today we have plenty of foreigners either working or studying in the country. And as the Prime Minister rightly mentioned, as regards marriage of convenience, the problem does not lie in the marriage, but in the intention of the non-citizen whose main aim is to continue to reside in the country, using as cover its residence permit as spouse. Some ill-intentioned persons have gone that far by marrying Mauritian citizens for the sole purpose of obtaining a residence permit to stay in the country. When facing restrictions, these foreigners invite citizens abroad and have recourse to a civil marriage in their country of residence. Hence, it is our duty as a responsible government to put an end to such abuse. And it is positive to highlight that Mauritius today is host to almost 30,000 foreigners, either workers or students. And Mauritius, Mr. Speaker, sir, is a jurisdiction which has all positive parameters to attract foreigners. And therefore, it is even more important for us to ensure that we have the legal means to secure our borders and to secure the population from unscrupulous persons to settle in our country. Mr. Speaker, sir, I wish to come straight to one point which has been criticized a lot by the opposition, the amendment being brought to the Mauritius Citizen Act, namely subsection 8, where the minister may in his absolute discretion and without giving any reason deprive any person of his citizenship of Mauritius if he has reliable information and is satisfied that it is in the interest of defense, public safety, or public order. And here, Mr. Speaker, sir, the same arguments of absolute discretion or arbitrary powers being given to the Prime Minister from the opposition. Firstly, Mr. Speaker, sir, if we go through the provision, this provision does not actually give the Prime Minister any absolute discretion. It does impose certain conditions under which the Prime Minister can activate this provision. That is, he has to have reliable information and he has to be satisfied that it is in the best interest of the defense or public safety or public order. These have to be met before this provision is actually activated, and thereon action is taken for deprivation of any citizenship. And Mr. Speaker, sir, the question is, what if tomorrow the Prime Minister does receive information that someone within our territory is a drug dealer, or is a sex offender, or is a terrorist? And of course, being the Prime Minister, so many information is relayed to him. We rely on intelligence. This is how the country works. And the Prime Minister receives such information that there is someone who has committed sexual assault in his country of origin, he's in our country. What do we do, Mr. Speaker, sir, as a responsible government, as a caring Prime Minister? What does the Prime Minister do? So, the Prime Minister should, as the law presently provide, serve a notice to that person, state the grounds to that person, and until then, the person being free within our territory. And for instance, a sex offender, leaving all our children, leaving my daughter, for instance, pray to that person. I think today, the world we're living in, it is important, if we mean business, if we mean to protect the population, if we want to protect the population, if we want to protect our borders, we need strong provisions in our law to ensure that action is taken when it needs to be taken. If there is intelligence that there are such persons within our territory, it is only right and only legitimate that the Prime Minister activates this provision and kick that person out of the territory. This is how these persons should be treated. Our land, our paradise has been secured, and we live by our culture, a Mauritian culture that has gone from generation to generation. Today, there is globalization. Today, we are opening borders. Today, we have many foreigners within our territory, but that does not mean that we need to tolerate or we need to host people that can be a threat either to national security or to public order. This is very important for all of us to understand. We are not only politicians, we are not only elected members of the parliament, we are also responsible citizens. And we need today to make a distinction, ce discernement entre cette personne to whom we can serve a notice and state the grounds and say, okay, we are depriving you of your citizenship, and that other category of person where he needs to be kicked out, I say it again, Mr. Speaker, sir, out of the territory as soon as we have intelligence, as soon as we have information that the person does not deserve to be in our territory. So, introducing when amending the Mauritius Citizen Act by introducing this new provision is only legitimate in the present context we are living. And Mr. Speaker, sir, it's nothing new about this section. Allons faire référence to England, to the UK. The British Nationality Act, under the British Nationality Act, the Secretary of State may by order deprive a person of his citizenship status. The Secretary of State may by order deprive him of that status if the Secretary of State is satisfied that deprivation of citizenship is conducive to public good. This type of legislation, this type of provision is already existing in the British Nationality Act. There's nothing new to it. When it comes to public good, when it comes to public order, we need to take the right action. So there is no room to come to this House and to come with lengthy speeches and arguments talking about democracy, talking about abuse or absolute discretion and all. Let me remind everyone that we have an index which is the Democracy Index 2021, Mauritius is ranked among the 21 countries who are categorized as a full democracy. So we are still on a worldwide scale recognized as a full democracy, though whatever is being stated by the opposition or by people outside this house who have ill intention and political motivation just to see that everything that is being done by the government is not right. Every single thing being done by the government, never right. Everything is being soit politisé, soit des attaques personnelles. We are seeing it every day, Mr. Speaker. So we are seeing on the radio, we are seeing in the press, we are seeing it. Today, on diabolise le gouvernement. On diabolise le gouvernement. Quelqu'un vient à la radio, he comes with a statement, he comes with a piece of paper, he says everything he wants, and we start pointing fingers. We need to know. Je le redis, on doit faire ce discernement entre la responsabilité du gouvernement, the national security of a country, and then la démagogie, Mr. Speaker, sir. It is important. This government, Mr. Speaker, sir, means business. It has a roadmap. It has a program. It has been proceeding step by step along that roadmap, along that program. Of course, come in the middle, COVID, but that also has been tackled seriously, diligently, responsibly. We are still doing the work that has been mandated, that has been thrusted upon us by the people of this country. And we will continue with our work. Aujourd'hui, venir avec des mensonges, venir avec la démagogie, come in the press or the radio and saying whatever you want. Ben, comme le Premier ministre le dit, l'avenir est très proche, va révéler la vérité et va éclairer la population sur tout ce qu'on entend autour de nous aujourd'hui. And at that time, Mr. Speaker, sir, the opposition that is grabbing the leg of that one person that is claiming to be the savior and the hero of this country, at that time, when the time will come, they will have to stick their head in holes and hide in shame. And Mr. Speaker, sir, that day will come very, very soon, where we will know who is responsible, who is working in the best interests of the country, and who is protecting national security of this country. And that is none other than the Prime Minister, Pravin Kumar Jagnnath, Mr. Speaker, sir. Mr. Speaker, sir, I think I've said what needed to be said about the point of, allons dire, le point de discorde par rapport à ce projet de loi que, à mon sens, a été l'objet de beaucoup de débats. So, I'm nearly done, Mr. Speaker, sir. The only thing is that today, I reiterate the fact that we need to have a very strong, rigid, and well-framed legislation to allow us not only to control the ins and outs of foreigners within our territory, but also to ensure the security of our population and ensure that people that are admitted to the country are people that will not disturb public order and will not disturb national security. I'm done, Mr. Speaker, sir. Thank you so much.
Prime Minister.
Mr. Speaker, sir, I've been very attentive to the lengthy debate. Now they're all going. Almost bon Dieu. Almost bon Dieu, c'est.
Order.
Non, t'as pas le faire macarena, toi. Allez, casse-paquet. What a shame. Look at this opposition. They have intervened. Mr. Speaker, sir, they have intervened in the debate, and I'm prepared to reply to them. I thought at least those who have intervened could have remained in this house to listen to my arguments. But look at them. It's house, empty house on the opposition. C'est une opposition avec le lion, le coq, le requin, moustache, et les corbeaux. But anyway, I can tell you, Mr. Speaker, sir, and I can tell the House, this is no distraction to me. No distraction to me. I'm focused. And I can tell you, Mr. Speaker, sir, that I will assume my responsibility to the hilt. So I have been very attentive to the lengthy debates by both sides of the House on this very important bill, which has in fact consolidated all the changes brought since its enactment in 1970 and has at the same time brought some pertinent amendments to address practical problems encountered throughout its implementation. And it is high time for new legislation to meet the emerging challenges posed and to alleviate the pains endured by many of our citizens by ill-intentioned non-citizens. Allow me to take this opportunity to thank all the honorable members who have intervened and brought their contributions to the immigration bill, which I presented last week. Mr. Speaker, sir, let me start by saying that the members, in fact, members of the government side have replied to almost all issues raised by members of the opposition. However, I would like to shed some further light on some few issues which may, if ever, still be shady. Before I make my comments on the points raised from the opposition, I would like to highlight the main objectives of the bill, which are, amongst others, to consolidate and strengthen the existing Immigration Act, which was enacted more than 50 years back, as well as to address suspected cases of marriages of convenience, which are on the increasing trend. It is a fact that fast developing countries with growing economies tend to have an influx of foreign nationals seeking permanent settlement thereat by various means. Mauritius has not been spared of this phenomenon. It is unfortunate that some of our citizens have been lured and abused by foreign nationals just for the sake of having permanent residence through the sacred bond of marriage. As the Prime Minister of this country, I cannot remain insensitive to the difficult situations faced by our citizens who become victims of marriage of convenience, and I am thus duty-bound to take appropriate measures with a view to addressing such problematic issues and preventing unscrupulous non-citizens to lure our fellow citizens for the sole purpose of obtaining the status of resident to enable them to continue to stay in our country. Apart from introducing a 2-year temporary residence permit for non-citizen spouses, consequential amendments are being brought to the Civil Status Act to provide that no marriage between a non-citizen and a Mauritian citizen would be celebrated in Mauritius before the expiry of a period of 30 days instead of the current 10 days, starting on the first day of the publication. This measure would enable relevant authorities to conduct appropriate checks on the non-citizen. Furthermore, other consequential changes are also being brought to the Mauritius Citizenship Act. Henceforth, a non-citizen who is married to a citizen and who intends to be registered as a citizen of Mauritius would be eligible to apply for the registration 4 years after having been issued with a residence permit as spouse. An aggregate period of residence of at least 4 years in Mauritius for both spouses would be considered, that is, the period of temporary residence would be considered when assessing applications for Mauritian citizenship. Mr. Speaker, sir, let me make a few remarks on what I heard from honorable members. First of all, I must say that this bill has been prepared in the best interests of our citizens. The primary motive of my government has always been that of placing people in the forefront of policies which affect them. In fact, my speech during the debates of the second reading of the Immigration Amendment Bill in 2019 bears testimony that I did inform the House that the existing Immigration Act needs a complete review, along with other related legislations, such as the Civil Status Act, the Mauritius Citizenship Act, and the Deportation Act. And to that effect, the different legislations were being examined in a holistic manner. Moreover, my government had signified its intention to review the legislation relating to immigration matters in our government program 2020-2024. Mr. Speaker, sir, during the past days, I've closely followed and listened to the comments aired by some people, not only on the radio, social media, and of course in this August Assembly. While it is good that citizens show interest to the amendments being brought through this bill, I am, however, surprised by some frivolous comments tending to the misconception that a Mauritian-born citizen can be deprived of his citizenship. I wish to emphasize that Section 22 of the Constitution of the Republic stipulates that, and I quote, "Every person born in Mauritius after 11th March 1968 shall become a citizen of Mauritius at the date of his birth," unquote. This is subject to either of his parents being a citizen of Mauritius. Mr. Speaker, sir, let me therefore at the outset point out that there is no provision in the Mauritius Citizenship Act or any other legislation to deprive Mauritians born in Mauritius of their Mauritius citizenship. The Act has, since its proclamation, been regulating the stay and grant of Mauritius citizenship to non-citizens. Hence, the new provisions will only affect persons who have acquired their Mauritian citizenship through registration or naturalization. The adverse comments made by some people to influence public opinion are therefore erroneous, ill-intended, and misleading. Mr. Speaker, sir, I am also disappointed by the comments made by Honorable Utim, who has supposedly analyzed the proposals made with, as he says, a loop. He has seen that we are depriving Mauritians of their citizenship. I would advise him to increase the magnifying power of his lens, to read the other parts of the bill where, in fact, we are doing the contrary of what he is saying by repealing unjust provisions under sections 5, 9, and 14 of the Act, which impose that a person should first renounce his citizenship of origin to acquire Mauritian citizenship, while in fact, Mauritius allows citizens to hold more than one nationality. And this would have been the case, Mr. Speaker, sir, incidentally, to Dr. Naveen Ramgoolam. Mr. Speaker, sir, the repeal provision has addressed an anomaly where the risk of a person becoming stateless is more apparent and more likely to happen contrary to international conventions. My government is correcting these unfair provisions. Mr. Speaker, sir, I would also like to reassure the House and the population at large that under Section 11.3b, Section 11.4b, and Section 12.1b of the Mauritius Citizenship Act, the Minister shall not deprive any person of his citizenship of Mauritius where it appears to him that the person would become stateless. These are the assurances and safeguards provided by the law to prevent rendering a person stateless for whatever reason, albeit being a non-citizen. In fact, the proposal to deprive persons of their Mauritian citizenship is targeted against those foreigners who have acquired Mauritius citizenship through fake marriages and those dubious persons, that is, criminals and fugitives such as Peter Jurisek, whom the Slovak authorities took care of him in April 2022. The same Peter Jurisek was planning to marry a Mauritian citizen to be able to live permanently in Mauritius. Just imagine what would have happened if he had already married the Mauritian and had already acquired the Mauritian citizenship. We would not have been able to hand him to the Slovak authorities. This is the type of persons we are targeting and whom the Honorable Utim fiercely defended in this August Assembly itself. That shows the true face, of the opposition. Mr. Speaker, sir, by amending Section 11 of the Mauritius Citizenship Act, it is specifically these types of situations that we intend to prevent. Mr. Speaker, sir, Honorable Utim evoked international conventions and gave the impression that we were not aligned to Article 15.1 of the Universal Declaration of Human Rights, which stipulates that, I quote, everyone has the right to a nationality, unquote, and Article 15.2, where, I quote, no one shall be arbitrarily deprived of his nationality nor denied the right to change his nationality, unquote. These are fully enshrined in our domestic law. In fact, Mr. Speaker, sir, all persons born from Mauritian parents on our soil acquire Mauritian nationality de facto. There is presently no reported, nor any recorded case of stateless person in Mauritius, either by birth or by the application of the law. With regard to the 1954 UN Convention relating to the status of stateless persons, I find it surprising that it is only now that Honorable Utim is finding that we have not ratified the convention after 68 years. But as we say, it's never too late. Mr. Speaker, sir, it is true that the African Union Convention governing the specific aspect of refugees problems in Africa, and which Mauritius signed as far back as 1969, has still not been ratified. This because we have reservations on some articles regarding refugees and asylum seekers where there may be serious legal and immigration implications for the country. Mauritius has in the past adhered to various other instruments on nationality. However, the Republic of Mauritius, being a small island developing state and a densely populated country with limited resources, we cannot ratify all international and regional conventions regarding nationality and statelessness for obvious reasons. Still, our laws contain many provisions on nationality derived from international instruments, and I must say some are even more favorable than actual provisions prevailing in many countries. Mr. Speaker, sir, the reputation of Mauritius cannot be disputed as a fair and democratic country, abiding to human rights on the African continent and at international level. In fact, in the year 2021, Mauritius received an A grade following an assessment made by the Office of the United Nations High Commissioner for Human Rights Committee for the implementation of recommendations of the legal obligation of states parties that have ratified the International Covenant on Civil and Political Rights linked to the treatment of asylum seekers, refugees, and stateless persons. What more testimony can we expect? Mr. Speaker, sir, some people have been making much noise these days about the discretionary powers of the minister. This is not a new provision and neither a new concept. In many laws, such discretionary powers are prevalent since long in Mauritius, as well as in other jurisdictions. Mr. Speaker, sir, nationality is one of the most important sovereign components of a country and is considered as a human right. However, some people are increasingly having resort to all sorts of maneuvers, either through marriages of convenience or under other schemes, to circumvent the law for the sole purpose to reside in Mauritius and acquire Mauritian nationality. It is therefore my responsibility as Prime Minister to ensure that this sovereign aspect is not used by ill-intended and unscrupulous persons or even criminals to hide in Mauritius and to commit other crimes under the cover as being a Mauritian national. Mr. Speaker, sir, Honorable Utim had in his speech went on with this argument on absolute discretion. I heard another member today talking about absolute discretion. He even said that we should remove it. Well, if he was serious, he should have been in Parliament to move for an amendment to remove it. Where is he? But they say that we should remove this absolute discretion by mentioning that the Immigration Amendment Bill in 2019 was aimed towards giving the Prime Minister an absolute power to deprive a resident of his status of resident, and referred to Section 6(1) of the Act. Let me inform the House that the Immigration Amendment Bill 2019 did at no time amend Section 6(1). In fact, the Honourable Member should not mislead the House. Section 6(1) of the Act existed since long, even at the time when former Prime Ministers were in power. The existing and prime provision, and the same provision at Section 6(1) has been included in this bill at Section 18(2). In fact, I must say, Mr. Speaker, sir, if the Honourable Member had taken the time to study the new bill with his loop and the existing Act, he would have certainly noted that several provisions of the existing Immigration Act has been kept as it is in the new bill. The bill has only consolidated and realigned all the provisions and amendments to make the legislation simpler. The same argument applies to the criteria for fit and proper person. Now again, Mr. Speaker, sir, I think Honourable Utim has very less argument on this present bill. That is why time and again he focused on amendments made to the Immigration Act in 2019. He mentioned that in 2019, the Prime Minister was given power to declare as prohibited immigrant any foreigner which in his opinion was likely to be prejudicial to the interests of defense, public safety, public order, public morality, or public health. I don't want to repeat the arguments of 2019, but let me inform the House, because it is good to know, that the amendments were made taking into account best international practices concerning immigration legislation. I informed the House earlier that immigration issues are not the concern of only our country, but of several countries, including developed countries. And that is why we have adopted their respective legislation to new challenges that are posed by growing. I did take examples of legislation in some other countries. For instance, in Singapore, and let me mention again, where Section 8 defined prohibited immigrants as, and I quote, any person who, in consequence of information received from any source or from any government through official or diplomatic channels, is considered by the minister to be an undesirable immigrant, unquote. Approximately similar provision. I also cited the example of New Zealand, where according to their legislation, and I quote, certain other persons not eligible for visa and entry permission include where the minister has reason to believe is or is likely to be threat or risk to security, or is likely to be threat or risk to public order, or is likely to be threat or risk to the public interest, unquote. To add on, I also took the example of Norway, where, and I quote, a foreign national may be rejected when it is necessary out of consideration for national security, public health, public order, or international relations of Norway or another Schengen country, unquote. Mr. Speaker, sir, to have in fact looked at their legislation and to have also been inspired by their legislation in order to enact best practices to address the going backwards. Are these countries going backwards? Mr. Speaker, sir, let me here inform the House of situations. And I hope one of these days, if the opposition will not dare to put that question, one member from the government would put a question with regard to people who have, where we have applied this provision in order to prohibit, to declare some people as prohibited immigrants. So that we then will know exactly in what cases, what kind of cases the Prime Minister has used this discretion. Since 2019, as I say, only a few foreigners have been declared as prohibited immigrants on the basis of information received. Let me cite a few examples. A Mauritian citizen informed the Passport and Immigration Office that she was rewarded a sum of 100,000 rupees for her marriage and that her spouse was not living with her. They got married in Bangladesh. The Mauritian spouse was 57 years and the foreigner 34 years. In a statement, the foreigner acknowledged having given the Mauritian citizen a sum of money for the marriage to be able to stay in the country. On the basis of the facts and averments of the citizen and non-citizen, the latter was deprived of his status of resident. In another case, two ex-Mauritian female spouses of a foreigner complained that their spouse had married them for the sole purpose of staying in the country. The foreigner sexually abused them, including forcing them to practice. I don't want to give details. The foreigner was also subject to indecent behavior towards his former in-laws. Furthermore, the ex-spouses were also victims of domestic violence. It was also reported that the foreigner sexually abused a minor of 13 years, and as a consequence of this act, the minor delivered a baby. The said foreigner then applied to get civilly married to a third Mauritian citizen. Do you think that we should have allowed such a non-citizen to abuse yet another Mauritian female citizen, Mr. Speaker, sir. Well, these are the people they are defending. Now, recently, whilst perusing documents submitted by a foreigner in relation to proposed civil marriage to a citizen, it was observed that the foreigner was convicted on not less than 15 occasions, including for offences related to consumption and supply of drugs. When this office raised an objection to the intended marriage, the foreigner did not turn up at the hearing. It was reported that he had left the country. In view of the serious nature of the offences and occurrences, as well as the risk that the foreigner would contract a civil marriage with a citizen abroad, he was declared a prohibited immigrant. And needless to remind the House of the case of Mr. Yurisek, where on the basis of reliable information to the fact that he was wanted in his country, amongst others, for establishing, masterminding, and supporting a criminal group, as well as illicit manufacture, possession of trafficking in narcotics and psychotropic substances, poisons or precursors. He was therefore deprived of his status of resident. For recall, he has already been sentenced to 22 years of imprisonment. And this is the kind of person that Honorable Utim has been vehemently defending in this National Assembly. Mr. Speaker, sir, in his speech, the Honorable Member mentioned that according to Section 24 of the bill, the Prime Minister is given the power in his absolute discretion to cancel the visa of a non-citizen. I note that the Honorable Member has cited only part of the section. In fact, the section reads as follows, and I quote, "Where in relation to the holder of a visa, the Minister, A, is satisfied that it is in the public interest to do so, or B, is of the opinion that the person is a prohibited immigrant, he may in his absolute discretion cancel the visa and that person shall be a prohibited immigrant," unquote. Mr. Speaker, sir, in the event a holder of visa is declared a prohibited immigrant, on the basis of a valid reason, or where the Minister is satisfied that it is in the public interest to do so, should there not be a provision to cancel his visa? Should the person be allowed to continue to stay in the country? As I say, as a caring government, I am duty-bound to act and take decisions. I ask myself the question as to whether Honourable Member expects foreigners who default the legal provisions of countries such as the United Kingdom or the United States of America or Australia to receive royal treatment. Look at what in other countries, what will happen. Can any foreigner allow himself to do anything he wants in these countries? In fact, the immigration laws are so strict in those countries that you can expect the foreigner to be deported right away without any right of appeal. Regarding the issue of wide powers of the Director General of Immigration raised by the Honourable Member, I wish to inform the House that presently immigration officers, being police officers, they already possess powers under the Police Act as mentioned in Section 25 of the bill. With this new bill, additional powers are being bestowed upon officers, that is, to summon and to hear witnesses. This is a common practice in many other countries, for example, like in South Africa, in the United Kingdom. And in fact, to prove that a marriage is a marriage of convenience, the immigration officer needs to have evidence, be it primary or documentary. Mr. Speaker, sir, as regards the appointment of the Director General, I again wish to point out that the Honourable Member should have done his homework well. With regard to the appointment, the principle has remained the same. The only difference is in the definition. According to the Immigration Act 1970, the immigration officer means a public officer designated as such by the Minister to carry out the provisions of this Act. And in the Immigration Bill, the Director General of Immigration has the same meaning And it has been the case. The appointed officer is a public officer. He is a police officer in this case, sorry. And it will continue to be the case in the future, unless, of course, we have another minister who decides otherwise. I also wish to emphasize that the concept of Director General exists in several countries, such as the United Kingdom and South Africa, and we are again aligning ourselves with international practices. Mr. Speaker, sir, I think I have canvassed and clarified in detail the need for coming up with this bill. I will thus end by thanking all the intervening honorable members for their contribution to the bill. I would also like to thank the staff of my office and the Attorney General's office for putting timeless efforts in finalizing this bill. This initiative will yet mark another achievement of my government in terms of honoring our engagement taken in our government program 2020-2024. With these words, I commend the bill to the House.
The motion seconded. The question is that the Immigration Bill number 12 of 2022 be read a second time. Those in favor say aye, those against say no. The ayes have it.
Public Bills Committee stage. Clause 1, short title. Clause 2, interpretation. Clause 3, delegation of powers. Clause 4, entitlement to admission to or to remain in Mauritius. Clause 5, restriction on admission to or to remain in Mauritius. Clause 6, status of resident. Clause 7, eligibility for temporary residence permit. Clause 8, eligibility for residence permit. Clause 9, residence permit for non-citizen spouse. Clause 10, residence permit for retired non-citizen. Clause 11, eligibility for permanent residence permit. Clause 12, eligibility for occupation permit. Clause 13, eligibility for short-term occupation permit. Clause 14, eligibility for family occupation permit.
The question is that clauses 1 to 14 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 15, deposit or bank guarantee. Clause 16, return undertaking. Clause 17, application for renewal of permit. Clause 18, deprivation of status of resident. Clause 19, seizing to hold status of resident. Clause 20, visa. Clause 21, non-citizen minors admitted to Mauritius. Clause 22, examination by immigration officer. Clause 23, powers to refuse admission to Mauritius. Clause 24, inspection. Clause 25, powers of arrest, detention, and investigation. Clause 26, removal of passengers. Clause 27, unauthorized disembarkation. Clause 26, clearance of vessels. Clause 29, security in respect of crew member. Clause 30, return passage ticket. Clause 31, identification number of residents. Clause 32, register of non-citizens. Clause 33, sharing of information. Clause 34, period of residence. Clause 35, lawful custody. Clause 38, Clause 636, offences. Clause 37, regulations. Clause 38, repeal.
The question is that clauses 15 to 38 stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 39, consequential amendments.
Move for an amendment to clause 39 as per the amendment circulated.
The question is that clause 39 be amended as per amendment circulated. Those in favor say aye, those against say no. The ayes have it. The question is that clause 39 as amended stand part of the bill. Those in favor say aye, those against say no. The ayes have it.
Clause 40, saving and transitional provisions.
The question is that clause 40 stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
The schedule.
The question is that the schedule stands part of the bill. Those in favor say aye, those against say no. The ayes have it.
Title and enacting clause.
The question is that the title and enacting clause stand part of the bill. Those in favor say aye, those against say no. The ayes have it. final question. The question is that I do report to the House that the Immigration Bill number 12 of 2022 has passed the committee stage with amendment. Those in favor say aye. Those against say no. Aye. The ayes have it. Please be seated. Honourable members, I have to report to the House that the Immigration Bill number 12 of 2022 has passed the committee stage with amendment.
Third reading.
That the Immigration Bill number 12 of 2022 be read a third time and passed.
Seconded. The question is that the Immigration Bill number 12 of 2022 be read the third time and passed. Those in favour say aye. Those against say no. Aye. The ayes have it.
Speaker, sir, I move adjournment of the House to Thursday, 28th of July at 1500 hours.
The question is that the House be adjourned to Thursday, 28th July 2022 at 3 p.m. Those in favour say aye. Those against say no. Aye. The ayes have it. The House stands adjourned. Specific matter, adjournment, none. Thank you very much.